Good afternoon. It is time for a Lawyer Reacts live outside of our regularly scheduled program over here because in the Idaho murders case, the probable cause affidavit has been released and the defendant, Bryan Kohberger, has had his first appearance in court where he was arraigned. So we're going to go through the arraignment together too. I think the arraignment will be really helpful to go through. Arraignments are really standard procedure. They make sure you have a lawyer or appoint you a lawyer and read out the charges, and we'll go through the charges together and what those mean. They tell them what the potential sentencing is, things like that. So we are going to go through the live court hearing. Well, the video court hearing. It is now a little delayed because I believe the court is not allowing live stream. They're allowing it to be recorded and then re-aired after court ends. So it's not contemporaneous, but it is live feed from court. Only a lawyer would take so many words to explain live. So we're going to go through that court hearing, and then we're going to go through the probable cause affidavit in its entirety, and then lots of questions. The reason that we are covering it is because this is a space where we can ask those questions and talk about the case that everyone is talking about right now in a space without diagnosing people, without, vitriol, and just talking about the facts. And that's what this community is so great at, whether we're covering criminal cases in court or whether we're covering pop culture legal dockets. The law nerds are the best community on the internet. So there will be timestamps down below for the replay crew. We're going to roll the intro and we just need to get into it. There is so much to cover today, but we're just covering this, and we will ask you will ask, and I will try to answer all of the questions that you have. So Q&A will be at the end. If you have those, we will try to grab them and try to hold on to them, but buckle up. There's going to be a lot of information in this probable cause affidavit. It's going to be sensitive information. I'm sure that's how these affidavits work. I was a criminal prosecutor for many a year. So there will be details. We will be talking about them with all the words. YouTube will be pissed. Whatever. We're going to talk about them because this is real life. This is how court cases work. And we're going to do it with dignity in mind for the victims in this case. And that is what I love so much about this community. So let's get into it. We're going to go to court first, and then we'll go to the documents second. All right, let's roll. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. So we are going to be going, I've seen multiple news outlets covering this, but the best audio is from Law and Crime. So we don't normally use them. They get a little confused about what is and is not copyright sometimes, but we're watching it live. We're using it for fair use. Law and Crime, this isn't yours. No, I'm not rolling out the new intro today. It's rolling out on the podcast, but we are not rolling out the new intro on a show with such a heavy topic. I feel like we'll do it when we talk about something lighter. Don't you worry. Don't you worry. We will roll it out. But today is just so heavy, and we're just covering the topics. So let's just get into it. We need to get into it and get into it with compassion. There's a lot here. So I'm sure some of you have already read this probable cause affidavit. So let's just all go through it together, but we're going to do the court hearing first. So if you've never been to a criminal arraignment, that's what we're going to do right now. We are going to the criminal arraignment. I have the sound the best I can. It looks like there are multiple cameras in the courtroom because I've seen slightly different angles depending on which feed it is. I was looking for a different feed, but here we are. Look, it's commentary. Whatever. We're just... Ask forgiveness, not permission. Law and Crime gets so spicy with their stuff. Look, Law and Crime, just stop worrying about it. You're a major news organization. Stop getting cranky because you're not us. All right, let's roll. This is the defendant in court for the arraignment. That is what will be a jury box if this ever goes to trial, and if it goes to trial in this courtroom. He is unhandcuffed in court. He is probably wearing protective gear. That's not unusual in a high-profile case. The judge is calling the case to order.
This is State of Idaho versus Bryan C. Kohberger, cause number CR 29222805. Mr. Kohberger is present in court. He is in custody. He is appearing with his attorney, Ms. Taylor, Mr. Thompson, Ms. Jennings, on behalf of the state. This is the time set in the matter for initial appearance. Mr. Kohberger, I am going to advise you of the rights that you have in this case. I am going to go over the criminal complaint with you, and then we're going to discuss setting the matter for further hearing.
All right.
You have the following rights. You have the right to remain silent.
Standard arraignment.
And will be used against you. You have the right to the presumption of innocence. That means the state bears the burden to prove that you are guilty of this offense beyond a reasonable doubt. You have the right to a preliminary hearing. A preliminary hearing is a probable cause hearing. At that hearing, the state must establish that more likely than not, these felony offenses were committed and you were the one that committed the felony offenses.
So what the judge has said there, that is our first kind of note about how this is going to go. The judge has made the defendant aware that he has the right to a preliminary hearing. And a preliminary hearing is exactly what the judge said. It is a probable cause hearing. It's a more likely than not hearing. When we go through the affidavit, a lot of the information in there is probably what they would present when this goes to a preliminary hearing. Is this person in custody being held over for crimes that they are more likely than not to have committed, that you can go forward to trial? We don't just hold people for unyielding amount of time without going to court and proving that they are likely the one who did it. This can happen through preliminary hearing or through a grand jury. A grand jury process is more secretive, et cetera, et cetera. But this is a preliminary hearing is really common. If there is a preliminary hearing in this case, I imagine it will be televised in some way. And then we will go through it. So they're going to read now the charges against him and talk about what those charges are and the potential sentencing for the charges, and reminding him, again, of his rights. You have the right to remain silent. You are innocent until proven guilty, etc. I'm going to turn this court feed up a little bit, and let's see if that helps. Let me know if it does.
You have a right to have that hearing within 14 days if you remain in custody.
That's not going to happen. It's going to get delayed.
Preliminary hearing to district court. If the court finds probable cause, you would be bound over to district court.
So when this judge is talking about district court, often the courts are split based on the court that does the arraignment has a different jurisdiction than the district court. So this is not going to be the final trial judge. That would be the district court. It sounds like this is the court, and the judge said at the beginning, and I didn't write it down. So this is the judge at the beginning that is going to arraign it and hear it through preliminary hearing, and then it will be bound over to a different court for trial after preliminary hearing. That's not uncommon in courthouses. That happens a lot in Los Angeles, where you have in Los Angeles, it was more of a misdemeanor court and then a superior court, but that's what's happening. And that's why she's telling him you will be bound over to a different court, to a district court.
And at that time, you can enter a plea of not guilty, and you can have a jury trial set within 6 months of your appearance in district court. At both your preliminary hearing and your jury trial, you have the right to confront and question any evidence or witnesses called against you. Call witnesses on your own behalf and compel witnesses to be present and testify at the state's expense. You have the right to be represented by a lawyer. If you cannot afford one could be appointed to represent you based upon your financial need. You also have the right to appeal any conviction in your case. Do you understand?
I appreciate that the judge is still checking their notes on the screen, because you have to hit every single one of these rights during an arraignment or it can cause a problem. So this is the judge making sure, and they do this in all of their arraignments. This isn't because it's just a high profile case or there's cameras. It's making sure you don't forget something, especially when you repeat something over and over all day. You can't miss any one of these.
Understand these rights?
Yes.
I am now going to go over the criminal complaint with you.
All right, so these are the charges.
Count 1 of the criminal complaint charges you with the felony offense of burglary. It alleges that the defendant, Bryan C. Kohberger, on or about November 13th of 2022 in Latah County, state of Idaho, did unlawfully enter a residence.
Hold on. I know the date, but I still didn't hear it. It's interesting to me that they put burglary first, and didn't charge the offenses in the most serious offense order. That's interesting to me. I need to hear the date again because I'm wondering if they're charging the burglary the day before because this happened in the overnight hours. So I am backing it up too. Ariel, you can just go watch it on Law and Crime. It doesn't hurt my feelings. This is a commentary channel, so I do, legal analysis and we explain things.
You also have the right to appeal any conviction in your case.
So I want to hear when that burglary is
Do you understand
charged.
these rights?
Yes.
I am now going to go over the criminal complaint with you. Count 1 of the criminal complaint charges you with the felony offense of burglary. It alleges that the defendant, Bryan C. Kohberger, on or about November 13th of 2022 in Latah County, state of Idaho, did unlawfully enter a residence located at 1122 King Road, Moscow, with the intent to commit the felony crime of murder in violation of Idaho Code 18-1401 and 1403. The maximum penalty for that offense, if you plead guilty or are found guilty, is not less than 1 year in prison, no more than 10 years in prison, and or a $50,000 fine or both. Do you understand?
Yes.
Count 2 alleges that you committed the felony.
It's interesting and of note that they specifically listed the intent for the burglary. So burglary is the breaking. They're reading the elements of the crime. The judge is reading the elements of the crime. The burglary is listed with the intent to commit a murder. So they're saying this was not he was caught in the house and then they came home and he was burglarizing the house and taking shit or whatever and then killed people to flee or escape. They have alleged that he went into the house with the intention to commit the murders, which is a big difference because there are plenty of cases where somebody is committing a robbery or a burglary or a home invasion, and then someone comes home and then you end up with them committing an assault or a murder to try to flee and escape or evade detection. This is different, and that is an important difference. So, Silver, when you're saying, damn, only 10 years, 10 years is for the burglary with intent to commit murder. That's actually higher. So there has to be an intent to enter. They listed this intent specifically as murder. So they are already getting to the premeditation here. So we will continue on, and then we will get to the probable cause affidavit.
Felony offense of murder in the first degree. It alleges that the defendant, Bryan C. Kohberger, on or about November 13th, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died, in violation of Idaho Code 18-4001, 4002, 4003, and 4004. The maximum penalty for this offense, if you were to plead guilty or be found guilty, is death or imprisonment for life. Do you understand?
Yes.
Count 3.
So he has to be advised of the maximum. He has to be advised of what he's facing, and he's being advised that this is a death penalty state and that his maximum, if he is convicted, is either death or life without parole. And then they're going to go through each of the additional counts, and they are tagging this date on November 13th, which again, if it happened, well, we'll get through the probable cause and we'll get some more information on the dates. We haven't gone through that yet. So this is what they are saying. He is answering the way a defendant should answer. He is supposed to just answer what the judge has asked, and not really have any response to that. So let us continue.
Alleges that you committed the felony offense of murder in the first degree. It alleges that the defendant, Bryan C. Kohberger, on or about November 13th of 2022 in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Kaylee Gonsalves, a human being, by stabbing Kaylee Gonsalves, from which she died, in violation of Idaho Code 18-4001, 4002, 4003, 4004. Again, the maximum penalty for that offense, if you plead guilty or are found guilty, is death and/or imprisonment for life. Do you understand?
Yes.
All right, we're going to continue going through these, but for those of you who are new in the chat, and there are some of you who are new in the chat, things that we don't do here as law nerds, we don't vote on what somebody's punishment is going to be at arraignment because there is a presumption of innocence, and I find it incredibly morbid. We are not going to disparage anyone involved in this case, including the defendant, no matter how distasteful you may find him and the things he is alleged to have done. I appreciate you. The mods will yeet you. And now that you understand, if you want to be in a free-for-all chat, the internet is full of Thunderdome chats where you can say all the negative things you wish upon this defendant. We just don't do that here, and I appreciate you for coming into our space and having a conversation about what is known and having a conversation about this case with dignity and keeping the focus on that. So we will continue on, and then I'm going to answer some questions, and then we will get into the probable cause affidavit. And again, no matter how overwhelming no matter how overwhelming the evidence against someone may seem at this point, we still have to go through the court process, or they can plea. But we give all defendants, no matter how distasteful, the right to their constitutional rights, because our constitutional rights don't matter much if we don't adhere to them in all circumstances, not just in the circumstances that we like. So, and that's where it's hard. It's hard to adhere to values when what you really want to do is be like, you know what, whatever. And if you don't like the rules, it's fine. You can go find lots of Thunderdomes across the internet and enjoy them. But we do things differently here. All right, let's keep going. Thank you, Lawners. Sometimes we just have to let our new folks know what the rules are in the chat, and so they can choose whether they want to be here or not. All right, let's go.
Count 4 alleges that you committed the felony offense of murder in the first degree. It alleges that the defendant, Bryan C. Kohberger, on or about November 13th of 2022 in Latah County, Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing Xana Kernodle, from which she died, in violation of Idaho Code 18-4001, 4002, 4003, and 4004. Again, the maximum penalty for that offense, if you plead guilty or are found guilty, is up to death and/or imprisonment for life. Do you understand?
Yes.
Count 5 alleges that you committed the felony offense of murder in the first degree. It alleges that the defendant, Bryan C. Kohberger, on or about November 13th of 2022 in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing Ethan Chapin, from which he died, in violation of Idaho Codes 18-4001, 4002, 4003, and 4004. And again, the maximum penalty for this offense, if you plead guilty or are found guilty, is up to death and imprisonment for life. Do you understand?
Yes.
And Mr. Kohberger, would you like to represent yourself, hire a lawyer, or see if you qualify for court-appointed counsel?
I have court-appointed counsel.
So the court asked, would you like to hire an attorney, represent yourself, or have court-appointed counsel? He has court-appointed counsel. That's who's sitting next to him. He would have gotten to speak to court-appointed counsel briefly, likely, this morning before this hearing. Court-appointed counsel likely would have said, you are going to be arraigned. You are going to answer only what is asked. This is what the arraignment is. We will talk to you more after this. We're going to get through this process. You're going to get the probable cause affidavit and probably give him one and let him read it and go from there. And for those asking to slow the chat down, we are as slow as we go, I think. So it's just a lot of people have a lot to say. So we are as slow as we go. The only way to get around slow mode really is to be a member because slow mode doesn't apply. Let's keep going and see what the end of this arraignment is.
Court has reviewed your application for attorney at public expense. I do find that you are indigent and do qualify for court-appointed counsel. I will appoint Ms. Taylor to represent you in this case. Ms. Taylor, have you had an opportunity to speak with Mr. Kohberger about speedy preliminary hearing and setting this matter?
Your Honor,
An interesting thing when we are looking at a small county is that there are not going to be a ton of attorneys that are qualified in a death penalty case. So I'm going to have to look at this attorney, but he's had his attorney appointed. There probably aren't that many public defenders that are death penalty qualified in this area, and there are qualifications to do death penalty cases when you are appointed by the state, and prosecutorial offices have their own regulations about what attorneys are qualified to do death penalty cases as well. So in areas where there are death penalty, there probably aren't that many attorneys in this county or in this state that are actually death penalty qualified. And the chat is saying there's like 6. I wouldn't be surprised. It's a small state, and this probably doesn't come up all that much. So I'm not surprised. I'm not surprised by that. So there's probably not a ton of defense attorneys who can take on this case, but also with the extradition, they would have known that he was coming. So they would have been able to run conflict checks and make sure that they found a court-appointed counsel that can do that. So there's a question, is court-appointed counsel always pro bono? I was trying to grab it from Jay. Is court-appointed counsel always pro bono? That's probably a more complicated question than what you're actually asking when I run it through my head. So court-appointed counsel, depending on the jurisdiction, can be public defenders hired by a public defender's office paid by the government. They can be alternate public defenders paid by the government in the alternate public defender's office. There's a reason why there's 2. Or they could be attorneys that are on a panel that also have a private practice that are appointed, but in that circumstance, they are also paid by the government. So pro bono indicates an attorney taking a case privately without pay, where this is at the state's expense attorney. So this is, I don't know if this attorney is an attorney with the public defender's office or appointed off of a panel of private defense attorneys paid for by the state. But either way, these are attorneys paid for by the state. And Brenda M said, I thought they weren't seeking the death penalty. That determination hasn't been made yet and probably won't be. The defendant has to be advised of the maximum potential sentence, even if the government is not going to seek that. We will see what the district attorney's office chooses to do. They will have to make that designation. They just aren't making that designation yet, and they don't have to make that designation yet. Diane over on Facebook asked, can a public defender refuse to take a case? If the way you're meaning is like, yo, fuck that guy, I'm not taking this case, not really. The public defenders, and I've worked with tremendous public defenders who I have the utmost respect for. They are great attorneys. Public defenders generally take the job that they take to ensure that the government does not overstep their power. So it doesn't really matter what the defendant did. They're doing their job by providing this person their constitutional defense and making sure that the state does their job properly and the government doesn't overstep. So no, they can't just be like, I don't want to take this case. Within a particular office, are there times when a particular case might hit too close to home, that you might have an internal conflict that you can go to a boss or a supervisor and say, I can't with this one? That depends on the internal workings of any given office. Can the public defender's office not take a case? Yes, that's why there's alternate public defender's offices. If there's a conflict, and getting into legal conflict is not what we have time for today, but if there's a conflict where the public defender's office, for some reason, cannot take the case because they've represented a victim in the case or previously represented another or represent another defendant and co-defendant case. You can't have both defendants represented by the same office. One will be represented by the alternate public defender's office. Then there can be conflicts. So they can't just be like, I don't want to do this. There's a whole structure for how they do that. But also when choosing a job, attorneys know that they're going to end up taking cases that they don't necessarily want to do. I've done it as a DA. I know defense attorneys who have done it who just do not love their clients, but they still have a job to do. And that doesn't just go for criminal. There's plenty of attorneys in private practice that take clients and they're like, I really don't like this person very much. I really don't like them very much. We're going to get through this case, especially when you're in a law firm where you don't have a choice. You're like, I don't really like this company very much, but I am their lawyer and I do my best. This is part of lawyers being lawyers and having like the lawyer side of your brain and then the like human side of your brain. Not to say lawyers aren't human, but sometimes we like split ourselves in two and you keep like the lawyer box separated. And it's something you start learning in law school is how to separate your thinking and your emotions separately and how to cordon things off. So that was a very, very deep answer, probably more than was anticipated. Do I think this person will end up representing themselves? Probably not. I think it would be a terrible idea. It doesn't mean people won't do it. I think they'll probably be very, very engaged in their defense. Everyone should follow Natalie Lawyer Chick. She is a public defender. She is. And she breaks down a lot of what goes on from the defense side. And I love having conversations with her because we come from Natalie Lawyer Chick is the kind of public defender that me as a DA would have enjoyed going out to lunch with when we were working in the same courthouse because she's just such a good person and she's a lot of fun. So that was a very long way of explaining conflict. Let us continue on. All right, as they finish up talking about whether he's going to waive his speedy preliminary hearing, I'm very curious to see what happens because he probably wants to know what they have to say and to see the witnesses against him. And that gets into two different things. Are we going to put in live witnesses or are we going to have the police officer testify to police reports and interviews and not have live witnesses? Let's see what's going on with preliminary hearing, but this also has to do with the defense attorney's case. He is just saying he understands the charges against him at this point. So we have not gotten to a plea yet, unless I missed it.
I have, we would ask the court to set a status hearing in a week or two to make a final determination.
That's fair.
And Mr. Thompson, Ms. Jennings are in agreement with that.
That's fine with the state, Your Honor.
So I don't know if she's going to have them waive their speedy preliminary hearing, but the judge is setting a status conference.
Set this matter for a status hearing then on the calendar on
Court calendaring is literally like rocket science. It's so difficult
January
sometimes.
12th.
That's fast.
At 10 o'clock a.m.
So status conference is going to set when
We will make sure notice is sent, and then
A prelim will
Ms.
be.
Taylor, do you wish to argue bail at this time?
no.
Your Honor, I would like to ask the court to consider setting a bond. Mr. Kohberger right now is on a no bond hold, but it's a limited request as I don't have enough information. We are new to the case. We haven't reviewed very much in the way of information about the case, and we have just done our own work on the case.
That's fair.
We would want the court to know that Mr. Kohberger has a good family that stands behind him.
So what the defense attorney said is, hey, he's on a no bail. It's not surprising in a quadruple homicide that he's on a no bail. He's on a no bail. Would you like to set bail? And she's like, we would like a limited hearing. She's not asking for a full bail hearing, which is a much longer process. And it's fair to say we just received this case. We don't have enough information, but he does have a good a family that's here and supports him or whatever. So I wouldn't be surprised if, because the status conference is only a week away, like a little more than a week away, that they just keep him on no bail. And then readdress that readdress that when they move on. And for those of you saying I can't hear the defense attorney very well, the defense attorney stood up to address the judge, and you can see that the microphone's down here on the table. And the defense attorney's not probably thinking about the microphone and the courts, but the defense attorney's mic's down there. But when they stand up to address the judge, that mic is not picking them up. So this is the defense attorney just really explaining we're new to the case, and this can be dealt with at the status hearing in a week. The court has already confirmed indigent status, which means he does not have the money to pay for his own lawyer. The state will be paying for his own lawyers, which can be a tremendously expensive thing in a death penalty case. So the state is going to be paying for his lawyers. So if the judge sets him a multi-million-dollar, bail, then I don't know if he would be able to even meet that to be out of custody. It's odd in a case so serious to see. We'll see. I mean, we'll see if the judge sets bond at some point, but that's a whole nother conversation.
And Mr. Thompson.
The state's position is Mr. Kohberger is not entitled to bond in this case. He can take charges as is noted on the arrest warrant itself.
So the DA said he's not entitled to bond based on the charges.
Under Code 19-816, 19-2903.
And is citing the law on that.
Given potential penalties in this case, there's no right to bail. The defendant was arrested 3,000 miles away across the country.
And you can probably see in the closed captioning a little bit more of what the DA is saying, but the DA is like, he was arrested 3,000 miles away from where this occurred. That needs to be a consideration. I also think part of the consideration in this case is with a high profile case, does it become a safety issue to have the defendant out? Not just the defendant potentially being a safety issue, but people trying to get to the defendant being a safety issue, because now we've got two safety issues. So yes, this is the same DA that we saw in the press conferences that I covered yesterday.
We're sadly asked that he remain in custody. No bail.
At this
point in
time,
pursuant to Idaho Criminal Rule 46B and Idaho Code 18.
Citing the law.
19-816 and 2903, I am going to leave the bail set of this case as no bail at this point in time until I have additional or further information at a later date and time. So with that, then Mr. Kohberger, you will be remanded in custody and remain in custody on the no bail pending further proceedings in this matter. Is there anything further in the case then for today, Mr. Thompson?
Yes, Sharon. The state is asking for no contact orders for their.
Interesting. So the state is asking for no contact orders. We're gonna see who those no contact orders are for. And no contact means he's going to be asking for the defendant not to contact someone. Can we express love for the DA's great beard? Yes. Yes, we can. We can absolutely express appreciation for his beard. I appreciate it. Santa in a suit looks somewhat strange. I appreciate it. I appreciate Santa DA. So we will see what the no contact orders are. That's an interesting. I'm interested. And hopefully we'll get some illumination on this when we go through the probable cause.
There is family members of the deceased and also the surviving roommates that spoke briefly with Ms. Taylor. She indicated there's no objection.
Of course there's no objection.
And Taylor, is that correct?
That is correct, John.
He asked for a no contact order with the surviving roommates and the victims' families. I'm not surprised by that. I don't think that would even be a consideration, but it might be out of an abundance of caution, or it might be something particular that they know about this defendant. Anything else?
So I will go ahead and issue those no contact orders. So I do have a no contact order then for the named individual of Dylan Mortensen, Bethany Funk, as well as the family members. And
I didn't know this was in here. In the probable cause declaration, they redacted out the names of the surviving roommates, but then in open court to put the no contact order in place, they've put the DAs did not redact out the names of the surviving roommates. I just would implore that again, law nerds, you are all kind, but that is not the judge's problem. That is not the judge's fault. The DA would have needed to have redacted those names, and there would need to be a reason to do so. But the DA did not redact those names to initials and then put them on the record. So I did not know that was in here. I know that I just want to make sure, well, that people don't go looking into the surviving roommates. But that's something that that we will not be zooming back to. I just want to say, keep in mind that these individuals are going through absolute tragedy and not to try to contact them. So I mean, their names are initials in the affidavit, and I'm going to use initials in the affidavit, but I know these names have already been out. Just I didn't know they that the DA would do them by name and not by by full name and not by initial.
And Mr. Chapin, the family members of Ms. Pernodal, excuse me. Yes, Mr. and Ms. Laramie, Mr. Mogan, Ms. Cheeley, and then a number of members of the Gonsalves family, Kohberger.
They're still
these no contact orders. What you do need to be advised of, and
we
what
were
will be in this no contact.
I zoomed through the rest of the no contacts order. I know the names are already out. I trust the law nerds. It's the rest of the internet that I do not trust. I trust the law nerds. But I zoomed through the rest of the no contact orders with the victim's family members because for our purposes, we just don't need it. The no contact order just means that he can't contact these family members. Will the defense attorneys have contact with them? Only if they are witnesses. So, and the defense attorney can do that in a respectful way.
Contact orders, you are prohibited from having any contact with them whatsoever. You cannot contact them through a third person in writing or by any electronic means. You cannot Facebook, Snapchat, Twitter, Instagram, use the phone to communicate.
This is just going through the no contact. No, there's not a standard way of handling this. It is if the names are and have already been out there, then the DA is not going to think to redact the names of adults, especially in a case that is not a case involving something like SA, where the victims have asked or not asked to be named or not named. In an affidavit, before things go into court and become public, that's different. They're going to be witnesses in court. They're probably going to be witnesses under their full name. So for the DA, no, in a high-profile case, is that something that may or may not have been thought of? Possibly, but then to do the no contact order, you need to do it by name because it's saying you can't have any contact with somebody's initials. DM doesn't give the defendant the adequate knowledge of who he's not allowed to contact. So it is a difficult thing if the names are and again, if the names are already out there and the DA knows that. So no, it's not a faux pas. I know that it has been going by initials in the affidavit, and I am going to keep it going by initials. So with that, it's not a faux pas. It's just I didn't know that was there and was kind of surprised. But again, you can't issue a no contact order without identifying the person you're not supposed to contact. So with this, is he using a public defender in a murder case? Yes, as many and most defendants do. And I think in a small jurisdiction like this, there was a huge benefit to having a public defender in any type of case because they're going to know the jurisdiction very well. And public defenders tend to do more trials than any other type of criminal defense attorney. So I'm not surprised that he has a public defender. Public defenders handle murder cases as a regular part of their work all the time. So
communicate with them or otherwise any form of communication in direct or indirectly with them. You cannot engage in any conduct that would harass, stalk, threaten, use, attempt to use, or threaten to use any physical force or violence upon them or place them in reasonable fear of bodily injury. Cannot go within or knowingly remain within 300 feet of their person. or their home, workplace, or
I mean, not going to be a problem. He's in
any
custody.
other place where they might be. There are no exceptions to these orders. And if you do violate these orders, it is a new misdemeanor offense. It is punishable by up to a year in jail and or a $1,000 fine or both. At this point in time, due to being in the magistrate's division here, at this juncture, I am going to issue the no contact orders for a period of 2 years. And then if it needs to be modified or changed by additional judge, it can be done so at that time. Is there anything further, Mr. Thompson?
And the no contact order in this might just be out of an abundance of caution and or respect to allow the families of the victims and the surviving roommates to know that he has been ordered not to contact you. He information is easy to find. Could he get on a jail call and call somebody and be like, what is this person's number? Yeah, it could happen. So it might just be for peace of mind. So.
No, Your Honor.
Anything further, Ms. Taylor?
No, Your Honor.
All right, thank you. We are adjourned.
All right, and that is the end of this court hearing, and we are going to go over the probable cause affidavit. Carol, I'm not going to back up the law and crimes coverage. I'm going to go through the affidavit myself with my own thoughts and expertise. So we're going to go through that, not their coverage of that. I don't think there's anything else from court. I'm just going to zoom and see if there's anything else from that. I don't think that there is. I think any other coverage I'm seeing is just them replaying this court hearing. So glad that we were able to go to the court hearing live, but now I'm going to look and see if there are any few questions before we move on and cover the probable cause affidavit and give anyone the opportunity to opt out and opt out throughout this. There is a gag order, so nothing else. No, we're not going to hear much else. We're not going to hear much else at all. So yes, please do that. Their coverage is over. I like the way I cover things. I'm gonna leave it at that. I like the way I cover things. So we're gonna do that. With that, I'm gonna go through a few questions about this hearing, and then we're going to move over. To the probable cause affidavit. Law and Lumber, good to see you. Reports are out that the defense attorney is on her game and was the driving force behind securing the scene so she could get the investigators on site. She was photographed there earlier. Good. I mean, he needs a good defense attorney. Again, there are probably very few death penalty qualified defense attorneys in the state. She had probably been contacted when he was arrested in Pennsylvania and had some time to know. We do know that the scene was shut down from remediation, and I'm not surprised by that. So that is absolutely fair. So that is absolutely fair. I'm not surprised. All right, I'm going to get to a few questions. If you are new here, you're welcome to put a 1 in the chat so the law nerds can welcome you with open arms to this incredible community we have. You can do the YouTube things. I am a YouTuber. I am. I've been an attorney for 17 years, but instead of being in court, I am now in my house, and it is great. I hope you're feeling better, Emily. Thank you. My mom surprised me with a Law Nerd hoodie, and it's my new favorite thing ever. Thanks for covering hard stuff. I get asked occasionally how I decide what to cover, and we are going to move on pretty quickly. But when we started covering the Darrell Brooks case, the amount of emails and DMs I got, and I don't always get a chance to respond, but I do see them, of people within the community of Waukesha who said, thank you for holding space, for having a conversation, for allowing room for emotion while still being respectful and non-disparaging and not being sensationalized. Thank you for just bringing the facts and not the fuckery and holding space for that. It gave us somewhere to be in community while watching something unfold that we want to know about that is really hard to go through. And that is part of how I choose to cover things. Mostly we stick to entertainment and pop culture, but there are things that are permeating the conversation and the kind of national conversation that I think I can bring not just this amazing community to, but bring respectful and helpful coverage of. And the community is a part of that. Knowing that we can be in a respectful chat and have a conversation is part of why I decide what to cover, when to cover it, and how to cover it. Everyone wants to know what's going on in this case. We want the details, but a lot of you feel really, really ick about the, oh my God, this, and did you just see that? Because it does feel ick. It does feel ick. It feels ick to me too. So we're just going to cover it and try to cover it without the ick and with compassion. So hang on, chat. I appreciate it. Christine asked, since he's highly intelligent, I mean, these are some assumptions. I'm going with that. And he is in a PhD program. I wonder if he'll want to defend himself. If he is highly intelligent, he will choose not to defend himself and be highly engaged in his defense. Is this federal? No, this is a state case out of Idaho, out of Latah County, Idaho, not a federal case. Is he going to rep himself? No, he said today he is taking a public defender. So, thank you, Emily, for a second stream. Thank you to the dearest mods. The mods are amazing. So thank you to our mods for riding a little bit later. We weren't going to have a stream the rest of the week, but here we are. It's just what's happening. We'll see if we need to stream tomorrow about the Jen Shaw sentencing. I don't know if we'll need to. Maybe we can just do it in a quick bits. The state still has the option of seeking the death penalty. That is correct. Would they decide at this next hearing? They don't have to decide that soon. And I imagine, well, not that I imagine. I can only tell you how it works in a bigger jurisdiction. I imagine there's conversations in a smaller jurisdiction because there's just less people involved. But in LA, there are panels that go over when you will seek the death penalty and not seek the death penalty. Presentations need to be made. It is a very, very serious decision on the prosecutorial end to decide to ask for the government to end someone's life. That is a large decision to make that the prosecution's in control of. That's a conversation that will be had with victims' families, that will be had, in this case, potentially with surviving roommates, maybe, maybe not, but with the victims' families within the prosecutorial's office. And each office will have its own guidelines of what kind of cases qualify. Is a special circumstance murder case enough? Is a premeditated killing? Is what details and what is the threshold for when you seek the death penalty that is really reserved for the worst of the worst of the worst, and what is the worst of the worst of the worst? And those are conversations that are really weird to have as a prosecutor, but especially in a big jurisdiction when you have a lot of different kinds of murder cases, you get a sense for where the worst of the worst is for an individual prosecutor and then for an office. So these are very long conversations that need to be had, and they need to go through all the levels of bosses and up probably to the elected district attorney in this area to make that conversation. Question: have you seen in your career where it was differentiated that the burglary was intent to kill? My personal cases, I didn't have any of the homicide cases I worked with that a burglary was involved. I'm not surprised. Not all burglaries have to differentiate what in the charging document, what the intent was. I was noting it because it gives you that very specific, he was not burglarizing a house and then a murder happened. This was the intent going in. So it gave us an insight into what the DAs think happened here. It gave us an insight into the events. Will this case be televised? I don't know if it will be televised contemporaneously or if they are letting people record and then share, but we are going to get some recordings out of here. Andrew Burkhart believes the district judge will be Judge John C. Judge. Andrea Burkhart is very smart. So that is, there probably aren't that many judges once you get to the magistrate court. So we will see. That'll be after preliminary hearing. But Andrea Burkhart does good work. And her assumptions when she's like, I think this will probably be it, she is generally right. So, all right. A lot of these other questions are getting to stuff I think that will be disclosed in the affidavit as we go through it. This is a first look for me. So I'm just warning. Why a gag order? Why a gag order in criminal law? Well, a gag order can happen in any kind of law. This is a small a small community, their jury pool is going to be very small, but I also think it's beneficial to all involved. If I was the DA in this case, I'd be glad for it. I'm sure law enforcement is glad for it. It also lets the media know what to expect. Setting expectations and setting boundaries is important, and saying, this is the information that's not coming out. We are not sharing anything else. We should not expect to see a 911 tape released. We should not expect to see anything other than court hearings and court documents going forward. I have seen reports that I am not going to address at this time because I have questions, but I have seen reports about whether or not the traffic stops were pretext stops and whether the FBI had asked for him to be tracked and stopped. If that information is coming out from law enforcement sources yesterday afternoon, that could be violative of the court order. And I've got questions about that too. So, because I haven't had the chance to think through that process, I don't have thoughts yet. I will have thought. I have a lot of questions, but I will have thoughts. But that's why it's partly to protect the jury pool and partly to stop the speculation. I touched on the defamation lawsuit yesterday. I don't know if we'll have time to get into it today, but there's been a lot of speculation about this case, and this kind of shuts all of that down and kind of closes any leaks. And it puts law enforcement, the DA and the defense attorney, all on equal footing. And for a defense attorney, I would imagine it would be frustrating that your law enforcement and the prosecution has gotten kind of out ahead of this. The defense attorney doesn't want leaks from law enforcement being, we knew this, or we suspect the motive is this. It keeps the case cleaner for a potential jury pool this way. Do I love it? No. Do I want transparency? Yes. But if they allow cameras into the courtroom and they allow access to the court documents, I'm fine with that compromise. I think that's a fair compromise. It stops unofficial leaks, it stops other channels of communication, and keeps it to what is in court is what's public record, is what's known to the public. I'm fine with that. I am. It can be frustrating, but like intellectually I'm fine. Even when my curiosity abounds, I don't know how much curiosity we need. So, all right. Let us continue into this affidavit. I am not going to tamp this down for YouTube much. So we are going to go through what is in this affidavit. I imagine parts of it will be graphic and will detail the killing of 4 young individuals, and that is going to be difficult. Just know this is on replay. You are always welcome to come back. You don't feel, if you don't want to go through this, that you need to go through this. It is okay to opt out. Just know. Ki, thank you for being in a chat. Xana was my friend's little sister. That's got to be heartbreaking for everyone involved. Look, I have lost people in my life to homicides. It is unique in the process that you go through. So we're going to be going through things. Just I trust all of you. So I trust the law nerds. Let us go through that. And thank you for keeping the chat a safe place for people who want to learn about the case and don't need all of the sensationalized yuck that we can so often get because I get to do what I want. That's why I'm a YouTuber. Exhibit A, statement of Brett Payne. Brett Payne's going to be a law enforcement officer. I should explain what this is. This is a probable cause affidavit. You need to have probable cause to arrest someone, to get a search warrant, those kinds of things. Those affidavits come from the police. They are supposed to be based on facts. They are supposed to be truthful. They are sworn affidavits. Lying in an affidavit is a crime. So this should be a recitation of the investigation to get us to how do we know that the person that we are seeking to detain, to search, to arrest, to what have you, is the person that we think did the things. How do we get there? It is not all of the information known. It is enough information known to get to probable cause. Do officers put everything they know in a probable cause declaration? No. No, they don't. No, they don't. They put what they need in because the probable cause standard is like a more often than not or more probable than not standard. They don't have to put every detail they know in, and they don't because they know this is going to become public record. Everything they know will not be in here. This will let us know what happened. And this is a public record, and we are going to go through it. So, the below information is provided by Brett Payne, who is a duly appointed, qualified, and acting peace officer within the county of Latah, state of Idaho. Brett Payne is employed by Moscow Police Department in the official capacity or position of corporal and has been trained and qualified as a peace officer for approximately 4 years. That seems short to me, but I also worked in bigger jurisdictions. Corporal Payne is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigation. There's the rest of it. On November 13th at approximately 4 p.m., Moscow Police Department Sergeant Bleeker responded to 1122 King Road in Moscow, Idaho. King Road residence, and I think that's what internally the police are calling this because that's how it's listed. The King Road murders is how they've designated it for things. So they've designated it by location, which is okay with me. It's better than giving it like nicknames, which again can also feel yuck to me, but it is the thing. All right. Simone, I am definitely trying to switch my brain to Moscow, not Moscow, but it's not always easy. My brain is difficult with me. It fusses. But you know that hopefully y'all you'll understand. So November 13th at 4 p.m. So these are all charged from November 13th, and I believe they were in the overnight from November 12th to November 13th. So this is at 4 p.m. This is well after a 911 call. You might see me taking notes because this is my first look through the thing. So if I need to take notes, I will. To assist with scene security processing of a crime scene associated with 4 homicides. That's going to be a lot of crime scene processing. Upon our arrival, the Idaho State Police ISP forensic team was on scene and was preparing to process the scene. So they had not started processing the scene yet at 4 p.m. MPD Officer Smith, one of the initial responding officers to the incident, advised he would walk me through the scene. Officer Smith and I entered the King Road residence through the bottom door on the north side of the building. Officer Smith and I then walked upstairs to the second floor. Officer Smith directed me down the hallway to the west bedroom on the second floor, which I later learned through Xana's driver's license and other personal belongings in the room was Xana Kernoodles. I hate it when we go by last name. They're always harder for me to pronounce, but that's what we're going with here after Kernodle. So this was Xana's room. Just before this bedroom, there was a bathroom door on the south wall of the hallway. As I approached the room, I could see a body, later identified as Xana's, laying on the floor. Kernoodle was deceased with wounds which appear to have been caused by an edged weapon. And again, the reason they're saying an edged weapon is because they don't know yet what type of edged weapon, and they're not going to know that until they go through an autopsy and determine. So police aren't going to say this is a knife, a sword, what kind of blade. They're just going to say it's an edged weapon, and that is appropriate. Also in the room was a male later identified as Ethan Chapin, here and after Chapin. Chapin was also deceased with wounds later determined. Autopsy report provided by Spokane County. So in court scanning, this is not a blank page that is scanned. This is the back side. The scanner picked it up because the redacted, unless there is something redacted here, but it seems to follow naturally that this is autopsy report provided by Spokane County Medical Examiner. So I think that's just the back page picked up by the scanner. Caused by a sharp force injuries. So again, that. I then followed OFC Smith upstairs to the third floor of the residence. The third floor consisted of 2 bedrooms and 1 bathroom. The bedroom on the west side of the floor was later determined to be Kaylee Gonclaves. Goncaves. I think I'm pronouncing that horribly. Gonclaves, I think. I later learned from review of Officer Nunez's body camera, there was a dog in the room when Moscow police officers initially responded. The dog belonged to Gonclaves and her boyfriend, Jack Decour. I found out from my interview with Jack Decour on November 13th, 2022, that he and Gonclaves shared the dog. Why is this noted? Because they are noting all of the things that were going on when they went in. So that all of you were telling me different pronunciations, Gonslabs. I'm not going to pronounce it well, and I apologize. That is my phonemic awareness, which is part of Gonzalez. All right, we're going to try to do it that way. Because I don't Gonsalves. Sorry, no, that's not sorry. That's much easier. Thank you, Kestrel. Thank you all for working with my brain. I appreciate it. I have not heard the names pronounced much, which see Gonsalves. The S helps. Thank you. So Officer Smith then pointed out a small bathroom door on the east side of the third floor. This bathroom shared a wall with Madison Morgan. Here after Morgan's bedroom, which was situated southeast. So there's going to be at some point a um a layout of this, and I'm sure that they have a layout of this. So as I entered this bedroom, I could see two females in a single bed, in the single bed in the room. Both Gonsalves and Morgan were deceased with visible stab wounds. Interesting that we've switched. This I don't appreciate. If we're going with the appropriate edged weapon, stick with the edged weapon, I think. I would go by first names, but it's going to cause a lot of processing as we're going through this to try to switch the writing, and that's going to be harder for me. So I would just like to get their names correct and not, and not be dyslexic. That's what I would like, truly. Because it does cause the pronunciation stuff I hate, but we are going through that. So we are reading through it. We are reading through it together. So Mogan's room, my brain transposed an R into there. Apologies. As I entered this room, I could see the two females. Okay, we went through that. The inconsistency of the edged weapon versus stab wounds. I don't know why there's an inconsistency here, but okay. I also later noticed what appeared to be a tan leather knife sheath laying on the bed next to Mogan's right side. That's an interesting detail. When viewed from the door, the sheath was later processed and had a Ka bar USMC at the and the United States Marine Corps Eagle Globe and anchor insignia stamped on the outside of it. The Idaho State Lab later located a single source of male DNA, suspect profile left on the button snap of the knife sheath. Look, man, leaving things at a crime scene are going to make it way easier for them to connect you to a crime scene. So leaving it in the crime scene is going to make it easier for them to connect you to the crime scene. If there is a knife sheath on the bed next to two deceased victims with your DNA on it, that's gonna make it hard. It's gonna make it hard. You guys are like, no, Emily, not K-bar, K-bar. I don't know. I don't know things. This is why we have a chat. Because I need the chat. Just to break tension for a minute there, before I was an attorney, I worked at a sporting goods store. And people regularly tried to steal things, shoes, golf clubs, whatever, from said sporting goods store. And we had a dude who I very, very vividly remember put on sneakers that he had tried on in the shoe department and grab a bunch of golf clubs and go running out the door as I'm like calling the police. Somebody from loss prevention gave chase. This person fled in a vehicle very shortly because they were trying to flee the wrong way and got into a vehicle collision. And then they tried to continue running, but they left everything in their vehicle: driver's license, phone, the golf clubs. So, this is not legal advice, and I never want to help people be better criminals, but it makes it easier for the DAs if you leave stuff at the crime scene that connects you to the crime scene, including things like a knife sheath when everyone had been, and now we know, stabbed, because that's what the charging documents allege, is that these were stab wounds. We know that was the cause of death from the autopsy report that was put out in press releases prior to this. So when you have the stab wounds and then you have the knife sheath next to deceased victims with DNA on it that has been connected to the suspect, it's going to be real interesting. As part of the investigation, numerous interviews were conducted by the police, by the Moscow department, the Idaho department, and the FBI Two of the interviews included BF and DM. Both were inside the King Road residence at the time of the homicides and were roommates of the victims. BF's bedroom was located on the east side of the first floor of the King Road residence. Based on numerous interviews conducted, that jumped. Is this going to straight to page 3? That seemed to jump. Oh, no, it's just awkward. Based on numerous interviews conducted by everyone, as well as a review of the evidence, I have learned the following. So this is going to tie us through what they learned in the investigation, leading them to believe they have probable cause that the person who committed these crimes is the person that they are seeking to arrest. On the evening of November 12th, 2022, Chapin and Kernoodle were seen by BF at the Sigma Chi house on the University of Idaho campus location from approximately 9 o'clock p.m. until approximately 1:45 a.m. On November 13th, BF also estimated at approximately 1:45 a.m., Chapin and Kernoodle returned to the King Road residence. BF stated that Chapin did not live at the King Road residence, but was a guest of Kernoodle. Gone slaves? Nope. This one is going to be hard. Gonsalves and Mogan were at a local bar at the Corner Club location in Moscow. They can be seen on video footage provided by the Corner Club between 10 p.m. on November 12th and 1:30 a.m. on November 13th. At approximately 1:30 a.m., they can be seen on video at a local food vendor called The Grub Truck at location in downtown. The Grub Truck live streams video from their food truck on the streaming platform Twitch. Interesting, which is publicly available for public viewing on their website. This video was captured by law enforcement. A private party, redacted, reported that he provided a ride to them at approximately 1:56 a.m. from downtown Moscow at the food truck to the King Road residence. DM and BF both made statements during interviews that indicated the occupants of the King Road residence were at home by 2 a.m. and asleep or at least in their rooms by approximately 4 a.m. This is with the exception of Kernoodle, who received a DoorDash order at the residence at approximately 4 a.m. When I was in college, DoorDash would have been an absolute godsend. We had like two things. We had like cookies and DP dough that would actually deliver to the dorms this late. But I can absolutely relate to 4 a.m. food. And this is actually really good evidence for a timeline for the DAs. Why? Because DoorDash and Uber and all of those things give a timeline tracking in their app that they can subpoena and get directly from the thing. It's like we can see when the person ordered, what they ordered, when it was received, when the driver left. You get all of that information, and that can actually be really, really helpful tracking information of when they showed up. So law enforcement identified the DoorDash delivery driver who reported this information. Oh, and they reported it. But this is information that can be tracked and downloaded and all of it. So that's really actually very, very helpful. DM stated she originally went to sleep in her bedroom on the south side of the second floor. DM stated she was awoken at approximately 4 a.m. by what she stated sounded like G playing with her dog in one of the upstairs bedrooms, which were located on the third floor. A short time later, DM said she heard what she thought was G saying something to the effect of, "There's someone here." A review of the records obtained from forensic download of Kernoodle's phone showed that this could have been Kernoodle, as her cellular phone indicated she was likely awake and using the TikTok app at 4:12 a.m. Phones are going to be a big part of this case because it's going to give them a timeline, a helpful timeline, because they're going to know what they were doing. But also, I mean, can relate. Just can. DM stated that she looked out of her bedroom but did not see anything when she heard the comment about someone being at the house. And again, I don't know if this comment would seem odd given you've got 4 roommates. They've been out, they've been having a night out. Someone coming home with someone doesn't seem too alarming at this point. Let's keep going. DM stated she looked at her bedroom but did not see anything when she heard the comment about someone being in the house. DM stated she opened the door for a second time and she heard what she thought was crying coming from Kernoodle's room. DM then said she heard a male voice say something to the effect of, "It's okay, I'm going to help you." That's chilling. Emily, just keep reading. Emily, just keep reading. At approximately 4:17 a.m., a security camera located at 1112 King Road, a residence immediately to the northwest of 1122 King Road, picked up a distorted audio of what sounded like voices or a whimper, followed by a loud thud. Those doorbell cameras, a dog can also be heard barking numerous times starting at 4:17 a.m. So between 4:12 a.m., this is just my brain thinking. So at 4:12 a.m., Kernoodle's on TikTok. Sometime right after that, they heard what might have been crying coming from Kernoodle's room and someone saying, "It's okay, I'm going to help you," which is chilling. And then at 4:17, we've got external evidence of distorted audio, a whimper followed by a thud, and then a dog barking at 4:17. The security camera is less than 50 feet from the west wall of Kernoodle's bedroom. That's awful. So like the human side of me is like, that's awful. And the DA side of me is like, that's evidence. Um, that's evidence that they are going to use that is going to chill a jury. Hearing audio evidence is so visceral, and we saw that in the Daryl Brooks case, particularly when they were playing through the audio of just the audio only of the music playing in the band in the car. It's so visceral. So from like the prosecution standpoint, that is collected preserved evidence that is going to be strong evidence of what happened there. We're not too tying a person to the thing. We're at a timeline of what happened. We will tie a person to a thing later in this affidavit, I am sure. But we are at tying together what happened. And this is going to tie together a timeline of what happened. And then what you're going to want to do as a prosecutor in front of a jury is take the timeline of what happened at the house and the timeline of where you know the defendant to be or not to be, and 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 match those together. So this is going to be powerful evidence for a jury and difficult evidence for a jury to listen to because they know what that is, or they are going to be able to tie together what they think that is. Yes, I know I need to keep reading. I need to keep reading. There is more. DM stated she opened her door. And for those of you in the chat, a lot of you are asking who's DM'd. DM is one of the surviving roommates. We talked about DM and BF earlier up. DM stated she opened the door for a third time and she heard crying and saw a figure clad in. DM stated she opened the door for a third time after she heard the crying and saw a figure clad in black clothing and a mask that covered the person's mouth and nose walking toward her. DM described the figure as 5'10" or taller, male, not very muscular, but athletically built with bushy eyebrows. Athletically built generally means not carrying some extra. I would not be described as athletically built, but that when we see the police transcribe into athletically built, it's like, they're just, fit, I guess. So 5'10" or taller, not very muscular, but athletically built with bushy eyebrows. Given a black clothing and mask that covered the nose and mouth, the eyes tend to stand out very much. I had a witness in a court case come into court and look to identify the defendant, and you could see the recognition in their face. And this was a defendant who had a nose and mouth covered and was like, I will never forget those eyes because they haunt me. So I'm not surprised we have so much detail about bushy eyebrows and eyes. I imagine that the person who experienced this, DM, if they have watched any of this coverage, will have a visceral response to seeing this defendant being arrested and detained if they recognize this individual, and that will be a very visceral response if they have to identify this person in court, because this will be a witness, if this goes to trial, that will be sitting in court and will be looking at that person and identifying them in court, which will be difficult. Bronwyn asked, why isn't this federal with him crossing state lines? There were no state lines crossed that we know of to commit this crime. He crossed state lines after, but when he crossed state lines after, he was not uh, restrained from doing so. There was no warrant out for his arrest. He was not named as a person of interest, so there was nothing to stop him from traveling freely about the country or even out of the country. I think if he had tried to travel out of the country, they probably would have stopped him, but he didn't cross state lines to commit this crime that we know of. This was a local crime committed locally. So let's see. So the male walked past DM as she stood in a frozen shock face. I can imagine. The male walked towards the backsliding glass door. DM locked herself in her room after seeing the male. DM did not state that she recognized the male. This leads investigators to believe that the murderer left the scene. So they are believing that DM saw the defendant leaving and then locked herself in her room. I can already see people saying, why questioning what DM's actions were. We're not through this affidavit yet. One never knows how one is going to respond in a circumstance, and so I'm not going to speculate about that. You never know how you are going to respond in a circumstance, and the information that they had was that something was off, and then they saw that person, but they froze. I'm not surprised that they froze. Freezing happens, so just be gracious. This person has been through it. The combination of DM's statements to law enforcement, reviews of forensic downloads from the records of BF's and DM's phones, videos of a suspect video as described below. So there's more video. Leads investigators to believe that the homicides occurred between 4 a.m. and 4:25 a.m. Okay, so that's the timeline. So after DoorDash left, that leaves me with questions. That leaves me with a lot of questions. And I see there was a question in the chat that caught my eye saying, from Brucey, I thought the roommates didn't see anything till midday. What we had with the information previously released about the 911 call is that there was a 911 call around noon. What I said yesterday is it is my assumption that these roommates had gotten home from a night drinking, had gone to sleep, had woken up the next day, because the 911 call, what we were told by law enforcement was it was for a non-responsive individual. So it was my assumption, which I said when we talked about it yesterday, and this is why I will always say this is me putting together these pieces, is that they had come home, gone to bed after a night out, potentially drinking, and then woken up the next late morning, as one is wont to do, and then went to check on their roommates or tried to check on their roommates, and they weren't responding, and then called police for someone that was non-responsive. This gives a whole lot more information that we didn't have yesterday that leads us with a lot more questions. So, will DM have to testify if this goes to trial? Absolutely. Both of the roommates will. So, I'm not going to speculate about what, with this information, why someone would or wouldn't have done things, because you never know how someone's going to respond, and we don't have all the information. So now we know that this person was up at 4 a.m., heard the things that they heard, and saw what the police believe to be the defendant leaving the scene. So we need to go through this some more. But it's not uncommon for people to freeze. And a lot of times people are like, well, why didn't they do this? And why didn't they do that? Brains are weird. Bodies are weird. Fight and flight response is weird. Trauma response is weird. We don't always know how we're going to do things. So we're going to give grace, and we're going to keep reading through this. And then as we get more information, we will ask more questions, because I'm sure we will have them. And this is not all of the information. This is not all of it. This is an outline of the information. So, what does DM stand for? It's the initials of the surviving roommate. So these are the initials of the two individuals, the initials of their names. So during the processing of the crime scene, investigators found a latent shoe print. That will be helpful information. Shoe prints are always good. I imagine they were looking for those shoes when they did that search warrant in Pennsylvania. This was located during the second processing of the crime scene by ISP forensic team by first using a presumptive blood test and then amino black, a protein stain that detects the presence of cellular material. The detected shoe print showed a diamond-shaped pattern similar to the pattern of a Vans-type shoe just outside the door of DM's bedroom. It's chilling if you're DM and finding this information out. Located on the second floor, this is consistent with DM's statement regarding the suspect's path of travel. So, what they're saying is the shoe print is likely traveling in the direction of travel that this individual said they were going, and it corroborates this is what I saw. And then they say, okay, well, and we see this shoe print going this direction. That was not maybe readily apparent, but they used amino black to make that shoe print more apparent. As part of the investigation, an extensive search commonly referred to in law enforcement as a video canvas, and we've seen this. I think the most recent case I've covered that we've talked a lot about a video canvas was the Jussie Smollett case, where they go everywhere there might be a Ring doorbell, a video camera, a surveillance camera, anything, and they try to get all of the footage they can first. Those systems so commonly overwrite, and some in 12 hours, some in 24 hours, some in 48 hours, but those things overwrite really quickly. And so they will go and grab all of the video surrounding. Rob in the chat said the Brooks case too. Yes, the Brooks case too. My brain went to Smollett because I remember so vividly the detectives talking about doing the video canvas in the middle of like a blizzard. So let's continue. Let's see. Somebody said that the suspect was wearing Vans when he was arrested. I don't know about that. We will see. All right. Let's continue on. So they did a video canvas in the area of King Road residence. This video canvas was to obtain any footage in the early morning hours of November 13th, 2022, in the area of the King Road residence and surrounding neighborhoods in an effort to locate a suspect or suspect vehicles traveling to or leaving from King Road residence. This video canvas resulted in the collection of numerous surveillance videos in the area from both residential and business addresses. So if they have a bunch of video, and I think they're going to tell us what the video has, the thing for prosecutors that will be helpful down the road for a jury is to have kind of a path of travel, and then to play the videos, like have a map exhibit. So a map of this is the location of the incident, this is wherever somebody went. Have that map and then play those videos to show how they parse together the map with the timestamps, assuming all the video has timestamps and the timestamps are accurate. Having to deal with surveillance video when the timestamps are not well kept and accurate means you have to bring in like 3 different witnesses to explain why the timestamps are not accurate to build your timeline. I have reviewed numerous videos that were collected and have had conversations with other MPD officers, ISP detectives, and FBI agents that are similarly reviewing footage obtained. A review of the camera footage indicated that a white sedan, hereafter suspect vehicle 1, we now know that they have determined that to be a Hyundai Elantra. We're going to talk about that, but this is the suspect vehicle 1, was observed traveling westbound in the area of the 700 block of Indian Hills Drive at approximately 3:26 a.m. Okay, so car is traveling at 3:26 a.m. At this location and Highway 95 nope, that's the early location. And then westbound on this avenue and Idaho State Highway 95 at approximately 3:28 a.m. Okay, so do we see it get to the house? On this video, it appeared that suspect vehicle 1 was not displaying a front license plate. I believe Washington requires front license plate. Does Idaho require front license plate? I think that they do. Idahoans, Idahoans. I'm going with that. Residents of Idaho, do y'all require front license plate? I'm assuming that you do, because it would note. I don't know if it would note it. Like in Tennessee, you don't have to have a front license plate, so the police would never say there was no front license plate, because there's never a front license plate. Which I love, because I don't have to put a front license plate on my car that I don't want to put a front license plate on, because it's unblemished in the front without a front license plate. But that's because I like my grill. So Washington requires it. I've lived in Washington. I know that. Idaho is like, yes, we require. All of you are saying Pennsylvania does not require. We're going to get to Pennsylvania in a minute, I'm sure, as we talk about license plates. But all of you are saying Idaho, it is required. Some of you are saying, no, it's not required. I'm wondering if it's required in Idaho, because otherwise, why would they say it? Like, why mention it? So those of you that live in Idaho, so they note that the suspect vehicle does not have a front license plate. I imagine if you're in a state where no front license plate is required, you don't make a note of that. That's all. So we're Kelly, you're reading ahead. We're not there yet. Idaho in here, and yes, thank you. Washington does, but I don't have a front license plate. Well, Kurt, don't disclose that. Just be like la 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 la. So, license plate mentioning came up later in the affidavit. I'm sure it will. I'm making notes of things as I see it because this is how I process information. So, anyway, and because we have a chat and we can answer things. A review of footage from multiple videos obtained from the King Road neighborhood showed multiple sightings of suspect vehicle 1 starting at 3:29 and ending at 4:20 a.m. Well, if our working timeline is 4 a.m. to 4:25, I have questions about this timeline. So, a review of footage from multiple videos obtained from King Road showed multiple sightings of the vehicle starting at 3:29 and ending at 4:20. So that's an interesting timeline. These sightings show suspect vehicle makes an initial 3 passes of the residence and then leave via Walenta Drive. Based off my experience as a patrol officer, this is a residential neighborhood with very limited number of vehicles that travel in the area during the early morning hours. Upon review of the video, there are only a few cars that enter and exit this area during the time frame. I don't like this at all. Like, I hate this for these victims. I like this for the prosecutors. Because for the prosecutors, I'm sure there are maps. We will get there. Sorry to scare. We'll get to maps, and they will be used heavily in trial. But also, I'm sure that if this is a smaller area, people might know these streets and be able to visualize this. We'll keep reading. But the 3 passes, again, when you're trying to prove first-degree murder, you need to prove that it's premeditated. 3 passes of the home and any information that we might get later of whether he had been in this area before this is going to give you that premeditation about whether or not these particular victims were targeted, which is just so chilling, because I don't know, there's never comfort in crime. There's not a lot of comfort for victims. But when things are random, when you're caught in the wrong place at the wrong time, when there's an accident, it's a little different than believing that a friend, a loved one, someone that lived down the road from you was targeted. And this leaves me with a lot of questions about whether these victims were targeted. So, and not random, which I think just by me making that statement, you can probably tell which way I'm leaning. Let's keep reading. Based off my experience, this is a quiet neighborhood. People aren't driving by. My neighborhood's the same way. Suspect vehicle 1 can be seen entering the area a 4th time at 4:04 a.m. Okay, so is that when the vehicle stops traveling? It can be seen driving eastbound on King Road, stopping and turning around in front of 500 Queen Road, number 52, and then driving back westbound on King Road. When suspect vehicle 1 is in front of the King Road residence, it appeared to unsuccessfully attempt to park or turn around in the road. The vehicle then continued to an intersection, that's interesting, of Queen Road and King Road, where it can be seen completing a 3-point turn and then driving eastbound down Queen Road. I'll just tell you why I think that's interesting. Because if this was an area that it would be easy to make a 3-point turn and turn around, it can show nerves. Whether there's more evidence of that or not, it's something that the prosecutors can argue. Again, I try to read that from a prosecutorial brain. With that, I see the chat saying, Emily, I swear you know what's coming. This is a first look for me. But also this is just me defaulting into my DA brain. So these are the questions I have as they come up. So that's what we do with a first look. We go through it all together. It doesn't give you any information if I just read it aloud to you. We can narrate things other times. I know y'all are here for the legal experience and the commentary. So, all right. Interesting driving behavior. Suspect vehicle 1 is seen next is next seen departing the area of the King Road residence at approximately 4:20 a.m. at a high rate of speed. So there's your more narrow timeline. The police indicate 4 a.m. to 4:25 in their initial pass of the timeline, and now we have someone unsuccessfully trying to park right after 4:04 a.m. and speeding off at 4:20 a.m. This is a tremendously short period of time, all things considered. So we're at like in that window between like 4:05 a.m., 4:04, 4:05 a.m. to 4:20 a.m. Right in that right in that window of when the roommate says that they heard things around 4 a.m. So this is also on video going to be good information for the district attorneys. So high rate of speed is always interesting. Suspect vehicle 1 is next observed traveling southbound on Walenta Drive. Based on my knowledge of the area and review of the camera footage, the neighborhood does not show suspect vehicle 1 during the time frame. I believe that suspect vehicle 1 likely exited the neighborhood at Pole House River Drive and that other street. Pole House is the southern edge of Moscow and proceeds into Whitman County, Washington. So this is right on the border there. Eventually, the road leads to Pullman, Washington. Pullman, I imagine, is near or around where WSU is, right? Pullman, Washington is approximately 10 miles from Moscow. Both Pullman and Moscow are small college towns, and people commonly travel back and forth between the two of them. So there's an assumption of the path of travel based on road and lack of video. Law enforcement officers provided video footage of suspect vehicle 1 to forensic examiners with the FBI. They regularly utilize surveillance footage to identify the year, make, model of an unknown vehicle that is observed by one or more cameras during the commission of a criminal offense. The amount of cameras in our society today is staggering, and you don't know until you're trying to. I mean, I guess maybe some do, but when you're trying to do stuff like this, you see so many, not just from Ring camera footage that are triggered by, or camera footage that are triggered by motion, but home surveillance, and then cameras too. If somebody's speeding through an intersection, it might get picked up by camera as well. And then once you get the license plate readers involved, if they identify this car in a license plate, then you get the automatic license plate readers, and then you start tracking a car's movement throughout location through license plate readers. So it'll be interesting if we get to ALPR information. Law enforcement officers provided video surveillance. The forensic examiner has approximately 35 years law enforcement experience, 12 years at the FBI. His specific training includes identifying unique characteristics of vehicles and uses a database that gives visual cues or visual clues of vehicles across states to identify differences between vehicles. After reviewing numerous observations of vehicle 1, the examiner believed that suspect vehicle 1 is a 2011 to 2013 Hyundai Elantra. Upon further review, he indicated that it could also be a 2011 to 2016 Hyundai Elantra. So we've got an Elantra between 2011 and 2016. As a result, investigators have been reviewing information for persons in possession of that vehicle. And we heard about that from law enforcement earlier in this, and now we know that that vehicle's been recovered and is probably being processed literally as we speak, because that just got recovered a few days ago. Investigators were given access to video footage on the WSU campus. A review of video indicated that at approximately 2:44 a.m. on November 13th, a white sedan consistent with the description of the white Elantra, suspect vehicle 1, was observed on WSU surveillance cameras traveling north on Southeast Nevada Street and Northwest Stadium Way at approximately 2:53. A white sedan consistent was observed traveling southeast on Nevada Street in Pullman towards SR 270. SR 270 connects Pullman to Moscow. So 2:53 in the morning, they have the I'm making notes, sorry. 2:53 a.m., they have what they think is suspect vehicle 1 heading towards the location. Okay. Which is interesting. If it's 10 miles away, that's not a long drive. I'm curious as to what was let's keep reading. I'm curious as to if they know any of the defendant's movements during this period of time. What they will also probably do, if they can, is track cell phone movement if they have if the defendant's cell phone is turned on. cell phone movement of the cell phone and the vehicle. So at 2:53, we see that this suspect vehicle driving this location. They probably have, maybe we'll get to it, Emily, keep reading. They probably have that cell phone ping, and they're going to try to connect those cell phone pings to a likely path of travel. Um, that evidence can be tremendously helpful to show the map of the cell phone ping, especially when you overlay it with video of a vehicle and where that vehicle is traveling, because it puts that person in the vehicle. This camera footage from Pullman was provided to the same FBI forensic examiner. The forensic examiner identified the vehicle observed as being a 2014 to 2016 Hyundai Elantra. At approximately 5:25 a.m., a white sedan, which is consistent with the description of suspect vehicle 1, was observed on 5 cameras in Pullman on campus. So this is after. So back on campus at 5:25 a.m. The first camera recorded a white sedan at location. The white sedan was observed traveling northbound, leads directly back to the West Polouse, I'm gonna get that wrong, River Drive. We're just gonna keep saying location in Moscow, which intersects. Let's see. Oh, this is where that road leads. So they see it back in Pullman, Washington at 5:25 a.m. The white sedan was then observed turning north on Bishop Boulevard and northwest on SR 270 at approximately 5:27 a.m. It's observed traveling northbound on Stadium Way. Um, depiction showing Moscow. This doesn't. Thank you. I'm sure it looks better not in the scans. And then they show the path of travel not to scale. White Elantra leaving WSU, White Elantra returning to WSU. So they've got points of interest here, and then the location that they're talking about. So they do have a map of where the vehicle is traveling. It'll be very helpful when this is like not a topographical map. On November 25th, 2022, MPD asked area law enforcement agencies to be on the lookout for for Hyundai Elantras in the area on November 29th. So this is probably when they, from the November 13th murders to now, or till November 25th, is probably in the time frame when they were doing the forensics, determining exactly what type of vehicle it was. That's not an unusual time frame. These things don't go as fast as one might hope or think sometimes, because it takes time to get all of those cameras downloaded. So on November 29th at approximately 12:28 a.m., WSU police officer queried white Elantras registered at the university. As a result, he located a 2015 white Elantra with a Pennsylvania license plate LFZ 8649. This vehicle was registered to defendant Bryan. It doesn't say defendant because this is a probable cause affidavit. He hasn't been arrested yet, not charged yet, not a defendant yet. I'm going to refer to him as the defendant just for clarity. So license plate here. I'm making a note of the license plate because I want to go look at the video of the traffic stop after this, because I don't remember if it was a Pennsylvania plate on that traffic stop. We're going to keep reading. I'm just telling you what my brain is thinking. The vehicle was registered to defendant residing in Pullman, Washington. The residence is approximately 3/4 of a mile from the intersection of Stadium Way and Cougar Way. Last camera location that picked up the Elantra. So they're saying, look, this is where the home is. This is where the location is there. This is where the vehicle is. So they can make a map of saying, look, he's doing the things. So yes, all of you who are like, well, then now there's state lines. We know what he was going there to do. I still think that it's a state case. I still don't think that in this area, I don't even know which federal prosecutors this would go to, Boise, but I don't know if this is something that federal prosecutors would take under their jurisdiction. I still think we've got an appropriate state case. So this is, I'm going to have to go back and look at that footage, but we're going to keep reading because that information might be here. So this is a Pennsylvania plate registered to the university LFZ at approximately the same day at 12:58. Different officer was looking for white Honda Elantras and located a 2015 at 1630 Northeast Valley Road in the parking lot. That's the same location as the apartment. Let's see. This location is an apartment complex that houses WSU students. Officer Whitman also ran the car and it returned to the defendant with a Washington tag. Well, why there's a Washington tag on it, but it has a Pennsylvania tag on it? Was the defendant switching his license plates? Did he switch the license plate before he went? Or did he switch the license plate after? Because when he registered the plates with the school has them registered as Pennsylvania plates. But when the car was observed with a Washington license plate. When were the license plates changed? We're going to keep reading. I reviewed the Washington state driver's license and photographed. The license indicates that defendant is a white male, height of 6 foot, weighs approximately 185 pounds. Additionally, the photograph shows that he has bushy eyebrows. His physical description is consistent with the description of DM, of the male that DM, the surviving roommate, saw inside of the King Road residence on November 13th. Further investigation, including a review of the sheriff's CPL Duke's body cam report, showed that on August 21st, 2022, Bryan Kohberger was detained as part of a traffic stop that occurred in Moscow. So on August 21st, he was in the area and detained. The traffic, y'all. 821. Look, this is why body cameras are so helpful. Because they've got body camera footage from August with him in that car. He's not going to be able to distance himself from that car, is he? Detained as a traffic stop, and he's in the area in August. So it's not like he's unfamiliar with the area. At that time, defendant, who was the sole occupant, was driving a 2015 Hyundai Elantra with the Pennsylvania plate. So in August, it had Pennsylvania plates, which were set to expire on November 30th, 2022, which could be a reason to change the plates. And the defense attorneys will be like, look, he's not changing plates to get away with anything. The tags were expiring. He doesn't have ADHD and doesn't forget to do things like register his car. He was just being a responsible citizen. So that's an argument for the defense. During the stop, which was recorded via a law enforcement body cam, defendant provided his phone number. Well, that makes it easier for law enforcement because they don't even have to make contact with him to start getting information by his phone. They have video of him providing his phone number during this traffic stop in August and could probably do a warrant to get that information before they even make contact with him. So 8458, hereinafter the 8458 phone as his cell phone number. So before they even have to make contact with him or arrest him, they can start to track his movements. Well, law enforcement, you must have been thrilled to have found this information. This would have been a day that all of the investigators were like, that is what we need. That is what we need. That right there. That is very, very helpful for them. Good on them for finding this traffic stop from August and being able to tie it together. Good on them for being able to tie back what kind of car this was. Look, when we talk about investigations being kind of slow and piece by piece, you're seeing this here. This is literally piecing together a puzzle. It's this, and it's this, and it's this, and it's this, and it's this. And that phone number is a big deal. Investigators conducted electronic database queries, learned that the phone was issued by AT&T, and I imagine subpoenaed AT&T immediately, ordered a search warrant for it because they probably had enough PC then. Anyway, that's not what we're doing. All right. On October 14th, defendant was detained. A lot of traffic stops. It gives police a lot of information, but there are a lot of traffic stops. What? Driving that Elantra like it's hot, man. On October 14th, defendant was detained as part of a traffic stop by WSU police officer. Upon review of that body cam and a report of the stop, defendant was sole occupant while driving a 2015 Hyundai Elantra with the Pennsylvania plate. On November 18th, according to Washington state licensing, defendant registered the 2015 Elantra with Washington and later received a Washington plate. So there's the new Washington plate from November 18th. Because the old one was expiring. Very responsible. Very responsible. Law and Lumber, no, we don't shame people for their driving stuff. This is just, it's helpful to police to have this many contacts. And yes, we don't ever shame anyone for failure to renew. These are difficult things to do, but this gives police quite a lot of information, doesn't it? So this, I imagine, is the plate we'll now see on the car. But I want to go look. I want to go look at I'm gonna go look at that body cam footage because there was a very clear license plate in the first body cam footage that came out with that Alondra or Elantra. Prior to this time, the 2015 white Elantra was registered in Pennsylvania, which does not require a front license plate to be displayed. This was learned through communications with Pennsylvania. They would have been like, hey, based on my own experience and communications with Washington law enforcement, I know that Idaho and Washington require front and back plates. See, the question gets answered if you just keep reading, Emily. Investigators believe that Kohberger is still driving the 2015 white Elantra because his vehicle was captured on December 13th by a license plate reader in Loma, Colorado. So now we're able to start searching for this car and see where it's passed through and where it's been. This probable cause affidavit is from the end of December, so from like December 29th. So that the Elantra was then queried on December 15th, 2022 by law enforcement in Hancock County, Indiana. On December 16th at approximately 2:56 p.m., surveillance video showed the Elantra in Albrightsville, Pennsylvania. So he's in Pennsylvania by December 16th. I imagine this is the road trip here. I need to go look at the dates of those other traffic stops. Because they've already started looking at him pretty closely now. So this would make sense that we're in Colorado and then in Indiana and then in Pennsylvania. In Pennsylvania, the sole occupant of the vehicle was the white male description consistent with defendant. Defendant and his has family in Pennsylvania, learned through TLO search and local tool database query. Based on the information provided by on the WSU website, defendant is currently a PhD student in criminology at WSU. Pursuant to records provided by a member of the interview panel for Pullman Police Department, we learned that his past education included undergraduate degrees in psychology and cloud-based forensics. These records also showed defendant wrote an essay for which he applied for an internship with the Pullman Police Department in the fall of 2022. Defendant wrote in his essay he had interest in assisting rural law enforcement agencies with how to better collect and analyze technological data in public safety operations. Okay, I'm going to keep reading. I have a lot of thoughts. Defendant also posted a Reddit survey, which can be found by an open source internet search. The survey asked participants to provide information to understand how emotions and psychological traits influence decision making when committing a crime. I've seen this discussed on the internet. Here's the thing: if they're going to ever use that, they're going to have to do all of the subpoena things to make sure that even though it was posted from an account that has this name, that account ties back to him. But the essay submitted to the police department is going to be an easier thing. This will be subpoenas. But again, this is a PC declaration. This is not a beyond a reasonable doubt thing. He wanted to help rural law enforcement with how to better collect and analyze technological data in public safety operations. I'm sure he's interested in reading this now. As part of this investigation, law enforcement obtained search warrants to determine cell device. There we go. Cell devices that utilize cell towers in close proximity to the King Road residences on November 13th between 3 a.m. and 5 a.m. After determining that defendant associated to both the 2015 Alondra and the phone number, investigators reviewed these search warrant returns. Those things take time too. Sometimes you can get them expedited, but search warrant returns take a minute. A query of the 8458 phone in these returns did not show the phone utilizing cell tower resources in close proximity between 3 a.m. and 5 a.m. Did he turn off his phone? Because I don't want to help people crime better, but If you're someone who is interested in cloud data and cloud-based forensics, one would be aware of the cell phone information that could be gathered by your phone and would probably turn that phone off. But this is from 3 a.m. We have, what page am I on? 12. We have we have car data heading into that location earlier than that. So it would be, this is not needed for the PC. This is just me thinking through, like, what does this look like at trial? If they have cell phone data before that period of time that connects him to being in the car, like I've got the video of the car and then the cell phone, that becomes very helpful because then you can say he's in the car. Me thinking through to the trial, this is not PC based, but you can say he's in the car traveling in that direction and turns off his phone. Why does he turn off his phone? Because he knows what he's going to go do, and he covers and studies cloud-based forensics and knows how much information you can get from a cell phone. So you turn it off. All right, let's keep reading. Based on my training experience and conversations with law enforcement officers that specialize in the utilization of cell phone records as part of investigations, individuals can either leave their cellular telephone at a different location, people do that, before committing a crime, or turn their cellular telephone off before going to a location to commit a crime. What'll be interesting is if we have data from before the crime to show how much he was in and around this area. What's also very telling and can be very telling is when the phone goes off and on. That can be very, very telling information that a DA can very effectively argue. Funny how the car is speeding away and the phone goes back on. And where does the phone hit when it goes back on? And connect that to the video of the vehicle. This is the fact that he was still driving this vehicle is an interesting level, is interesting to me. I'm not, Emily, don't help people crime better. Okay. This is done by subjects in an effort to avoid alerting law enforcement that a cellular device associated with them was in a particular area when a crime is committed. Yes, because they're well aware that this can be done and easily. I have used this. And I stopped prosecuting in 2017. I imagine the data is much better now. I also know that on numerous occasions, the loss prevention at Target can basically see your DNA from their cameras. They know everything. You can see the ink flecks on a check if you're signing a false one in store, and they zoom in. I imagine that the amount of information you get from cell phone tracking and from app tracking is substantial now. Okay, let's keep reading. I also know that on numerous occasions, subjects will surveil an area where they intend to commit a crime prior to the date of the crime. Yeah, when the crimes aren't crimes of opportunity, when they are, premeditated. Depending on the circumstances, this could have been done a few days or for several months prior to the commission of a crime. During these types of surveillance, it is possible that an individual would not leave their cellular telephone at a separate location or turn it off since they did not plan to commit the offense on a day. If you're canvassing a location, you're intending to do something. On December 23rd, 2022, I applied for and was granted a search warrant for historical phone records between November 12th at noon and November 14th at noon. I want more. Let's expand that search. Hopefully they will be for trial. Hopefully the DA will expand that search. For the phone held by phone provider at AT&T approximately 24 hours preceding and following the times of the homicides on December 23rd, 2022, pursuant to that search warrant. And by the way, the DAs can start issuing additional warrants, by the way. So they can, those types of investigations, now that there's been an arrest, those types of investigative things can now be done where they can say, okay, we want the cell phone location. They can ask for more than that now. On December 23rd, 2022, pursuant to that search warrant, I recovered records for the phone. Those records indicated that the phone is subscribed to that defendant at that address in Pennsylvania. And the account, which isn't surprising that the phone's registered to the family home in Pennsylvania, not to the student location. The account has been open since June 23rd, 2022. Oh, that's a newer phone. That might be something that might be absolutely nothing. These records also indicate a historical cell site location. I don't know. I'm very attached to my phone number. Maybe I'm weird that way. I'm very attached. Like, I don't want to change phone numbers. These records also indicate historical cell site information for the phone. After receiving the information, I consulted with the FBI, that is a certified member of the cell analysis survey team. I imagine they don't do a lot of this in a smaller jurisdiction, and so that's appropriate to expect. Members of that team are certified with the FBI to provide expert testimony in the area of historical cell site location and are required to pass extensive training that includes both written and practical examinations prior to certification with CAST, as well as the completion of yearly certification requirements. It's a lot of information. Additionally, the FBI CASTSA, the acronyms that I consulted with over the 15 years of federal law enforcement, has over 15 years of federal law enforcement, 6 years with the FBI. From information provided, they determined locations for the phone on November 12th and 13th. Okay, let's get to those. On November 13th at 2:42 a.m., the phone utilized cellular resources that provided coverage for 1630 Northeast Valley Road. So this is that location on campus that's believed to be his residence. Oh, no, that is his residence. At approximately 2, so this is November 13th. So at 2:42 a.m., he's home. On approximately At approximately 2:47 a.m., the phone utilized cell phone resources to provide coverage southeast of the resident, consistent with the phone leaving the residence and traveling. Oh, here we go. Phone car. Emily, keep reading. Emily, keep reading. Emily, keep reading. This is going to put phone in car, which makes it much easier to say he's also in car. Like nobody else is driving the car, nobody else has driven the car, and now the phone and the car are together. He's in the car. The phone is with him. He's in the car. This makes it much easier to argue. So phone in car, traveling. This timeline, they're going to have a really tight timeline. And when I go back through this, I will go back through the timeline when I look back over this and look at the timelines of the videos, and I will link these together for myself instead of making y'all flip back and forth, which is why when I break down stuff like this, I will eventually print it out so I can flip it back and forth. But I will look at those video timestamps of him leaving the WSU campus and then the cell phone timestamps and look at them together and see how closely they are associated, which is why I was starting to take some notes because we had him leaving because I can't physically flip it back and forth because I don't have it printed out yet, but he was leaving that area in the morning as well. So these are going, I imagine that these will coordinate when he's leaving the residence with the phone pings and the car pings. So this is the day, this is the early morning hours of the day of the homicides. At 2:47 a.m., he's rolling. This is consistent with the movement of the white Alondra. I mean, you said that much more succinctly than I did. I keep reading. At approximately 2:47, the phone stops reporting to the network. So leaving the area stops reporting to the network. This is consistent with either the phone being in an area without cell coverage or the connection being disabled, such as putting the phone in airplane mode, or that the phone is off. So, when and if this goes to trial, you look at whether you look at what if they want to. I mean, it depends on what other evidence I have, but you look at the path of travel, and generally law enforcement's going to be able to say, and even the cell company can come in. I've had cell company witnesses as well. The cell company can come in and say, hey, there aren't drop zones in this area. This is not consistent with being out of cell service range for AT&T. There is service range. Like here's the map and here's the path or the suspected path of travel, and this is not a no cell area. And then the DAs can argue, look, this is not a phone dropping out of cell coverage. It's not like he's driving into an area with no coverage. This is a choice. And then they can start to argue that as part of the proof of premeditation. Just my thoughts. The phone does not report to the network until approximately 4:48 a.m., which is consistent because the car is seen speeding away at 4:20. So this is 20 minutes after the car is speeding away, at which time it's utilized coverage of Highway 95 south of Moscow near Blaine. Between 4:50 and 5:26, the phone utilizes cell resources that are consistent with the phone traveling south on State Highway 95 and then traveling west towards Uniontown and then north back to Pullman. I want I have questions about the path of travel, like what's on the path of travel? Is the path of travel to evade detection? Like why the path of travel? But we're going to keep going. At approximately 5:30 a.m., the phone is utilizing resources that cover Pullman, consistent with the phone being back to the residence. The phone movements are consistent with the movements of the Elantra that is observed traveling north on Stadium Drive at approximately 5:27 a.m. So there's that layering of the phone is pinging here, the car is here, the defendant lives here. Based on a review of the phone's estimated locations and travel, the travel is consistent with that of the white Elantra, which is a big, big deal for showing the defendant's movements that day. So even though someone might think, "Oh, I'll just turn off my phone," or don't with the all. A further review indicated that the phone utilized cellular resources on November 13th, consistent with the phone leaving the area of the residence at 9 a.m. and traveling back to Moscow the next day. Specifically, the phone utilized resources that provided coverage to the King Row residence at 9:12 a.m. and 9:21 a.m. Back to the scene at 9 a.m. Returns home at 5:27 a.m. and goes back to the scene at 9 a.m. Why? Want to know if the police are there yet? Want to see if they're collecting evidence? Want to see what they're doing? Want to see if you've been discovered yet? Driving the car back to the area? I wonder if they have the car on video too. I bet they do. Oh fucking hell. Okay. Well, that's going to be interesting for the DAs to argue. Let's keep going. The phone next utilized resources that are consistent with the phone traveling back to the residence at 9:32 a.m. So in the area for a brief amount of time, 9:12 a.m., 9:21 a.m. So leaves, this is an interesting path of travel. Leaves the house at approximately 9 o'clock a.m. and by 9:12 is in the area of the residence. I mean, when they say it's close, that's 10 minutes close. I have all the things I want to say, but they're not nice. And then at 9:21 a.m. it's pinging, but then 9:32 back at the residence, which is consistent with that like 10-ish minute drive. 10 minutes. You guys are like, he probably noticed he was missing the knife holder, the sheath. Not going back into the location. Unbelievable. DA brain is like, well, I can picture the closing argument now. Human side, human empathetic Emily brain is like, this is not someone who's freaking out. This is someone who wants to know what's happening. This is not someone who's scared. This is not someone who's hiding. This is, to me, someone who is confident enough to take the car that they fled the scene in hours before back to the scene. I have not nice things to say. But for the DAs, this is a powerful argument when you are arguing the type of person that is doing this, and you argue the premeditation and the way this is carried out and how cold it was. So this is wanting to see, I think. Below is a description, not to scale, of the possible route taken based off the cell site locations. Route. This is a possible route. Okay. Investigators found the phone did not connect to a cell tower that provides service on November 14th in Moscow, but investigators do not believe the phone was in Moscow on that date. The phone did not connect to any towers that provide service to Moscow since that date. So after the 13th, after this trip back, when did this news start to break? I'll have to go back and look. Candy's Life said this is a very deliberate person. It seems to be. Based on my training and experience and facts of the investigation thus far, I believe that defendant used the phone, was the driver of the Elantra that is observed departing Pullman, and that this vehicle is likely suspect vehicle 1. Additionally, the route of travel of the phone in the early morning hours of November 13th and the lack of the phone reporting to AT&T between 2:47 a.m. and 4:48 a.m. What were you doing? You weren't on TikTok. You weren't ordering food. What were you doing? What were you doing? Sometimes the phone can be off, can be just as powerful information as the phone being on, because the fact that the phone's not doing other shit speaks volumes. You're not scrolling. You're not on the phone. You're not on the apps. You're not doing things. That can also speak volumes. It's consistent with defendant trying to conceal his location during the quadruple homicide that occurred at the King Road residence. On December 23rd, I was granted a search warrant for defendant's historical cell site. Like, oh, we have it. Oh, good. From June to, oh, not good. Oh, God. If it's in here, it means there's reason that it's in here. I mean, I'm glad to know that they have it. I'm not glad that it's in this probable cause affidavit, because that likely means that what we're going to find is that he was going to this residence a lot. Let's find out. Okay, so historical cell phone data from June 23rd, 2022 to current prospective location information, a pen register trap, and trace on the phone to aid in efforts to determine if he stalked any of the victims in this case prior to the offense. Conducted surveillance on the King Road residence, was in contact, whether he was in contact with any of the victim's associates before or after the alleged offense, any locations that may contain evidence of the murders that occurred on the 13th, and location of the white Elantra registered to him, as well as his location. So now they're tracing his phone. So they actually are able to keep a little bit of a beat on him, because he kept his phone and he kept his car after this, which is either stupid or arrogant. Probably both. All right. Let's see. The chat is letting me know. Thank you, Jessica. There's literally 9 miles between the two locations. Yeah, which makes sense. That it's taking about 10 minutes. That seems to be about appropriate, given the rate of speed he could travel between those spaces and the time of day. All right, let's get into information I don't want, but that's probably going to be in here. On December 23rd, 2022, pursuant to the search warrant, received historical records for the phone from AT&T from the time of the account being opened in June 2022, able to determine locations for the phone from June 22 to present, the time period authorized by the court. So this is all search warrants before the incident, or search warrants that go before the incidents that happened after, before the arrest. The records for the phone. Oh, my voice. Sorry, y'all. Recovering from being sick is hard. All right. Let's see. The records for the phone utilize resources providing coverage to the area of 1122 King Road on at least 12 occasions prior to November 13th. Well, if you're going to argue premeditation, 12 prior visits is going to go a long way in that. I can't imagine how chilling this must be for the surviving roommates, and I can't imagine how horrifying this must be for the family members of the victims, because it's just. But this, when you look at, do the police have enough evidence to arrest someone, they are very methodically laying out the puzzle pieces. And this, we're going to sidebar for a second. 12 times is a lot. We're going to sidebar for a second. In both of the press conferences that we watched yesterday, you see everyone saying, wait until the probable cause declaration comes out. Just wait until the probable cause declaration comes out. Now I understand why now I understand why the DA was like, we think this dude wants to know what's in the PC. He wants to know how they got him. So it's interesting to see the DA in Pennsylvania say, I think he wants to get back to Idaho and waive extradition because he wants to read this probable cause declaration because he didn't get it until he got personally served it in Idaho. So when he gets personally served this in Idaho, what he is going to realize very quickly is that he fucked up and that the car is on video and they know where your phone was. So he wanted to know that information and know what the police knew. And I can understand more why the DA was like, this is what he wants to know. And now we all know, but this is also why the police in Moscow were like, hey, wait until the probable cause declaration comes out and you can see the police putting the puzzle pieces together. But each time they need to get another search warrant, this is due process at work. They need the information. So they get the narrow search warrant and then they connect things together and then they go and get a search warrant that's broader and say, now we need this search warrant to give us this time. And they go through the building of the case piece by piece by piece. And it is time consuming. Search warrant turnarounds take time. And even then, the amount of information they processed in a month plus is still pretty fast. But this is just absolutely chilling for these victims that he had visited this location 12 occasions prior to these deaths. So there's more information I want to know, but I'm just going to keep reading. We're just going to keep reading. All of these occasions, except for one, occurred in the late evening and early morning hours of their respective days. Is what that indicates to me, or what I think I would argue if I were the DA, is that he is trying to understand what this area is like during the time of day, night, that these crimes would be committed. This is the same way somebody would case a bank to rob it. This is casing a location. That is how it reads to me. They have more information than I do, but this is what it seems like to me, is that this is the time frame I'm going to be there. I don't need to be there during the day. I'm not going to be in the area during the day. How this was picked, we might never know. I don't know if I want to know. I don't know if the public needs to know. I hope those answers are, I don't know if those answers are even helpful to the victims' families, because who knows? I don't know. Maybe that information will come out on trial. Maybe it wasn't. Maybe it won't. But if he was someone who knew them, it wouldn't be so weird that he's there 12 times. But that isn't indicated here. So for me, it seems that this could indicate, and this is my thoughts. It seems that he was there during that time of day to understand movements, understand how many people were in the areas, and understand all of that. So Bluebell asked, have I seen PC affidavits this detailed before? In serious cases, yes. This is in serious cases, yes. This is a lot of detail. It is a lot of detail, but this is a small this is a quadruple homicide in a small jurisdiction. So I think this is maybe better more than less, and they have the information. So anyway, so I just yeah. And just we'll see. But these are my questions and things if I'm going through this case, these are things I want to know. Is there another explanation for this? Is there a reason that he's there? Or is this canvassing? I want to know. That's what I want to know. On these occasions, on August 21st, 2022, the phone utilized cellular resources. Isn't that the day he got pulled over? What day did he get pulled over? Did I make a note? Yeah, August 21st was one of the days he was pulled over when he provided the phone. On August 21st, the cell phone utilized resources providing coverage at the residence from approximately 10:34 p.m. to 11:35 p.m., so for an hour. At approximately 11:37, he was stopped. Look, keep reading, Emily. He was stopped, as mentioned above. The phone was utilizing cell resource consistent with the location of the traffic stop during this time. That's really, really good evidence. That's really good evidence. And the reason I say that's really good evidence is because it, again, is really solid evidence. Not only did he say that that was his phone number, he's not going to be like, oh, it's not my phone. You're on video saying that that's your phone number on body cam. But we know that that's his phone, and we know the phone's in the car, and we have a police officer saying, I stopped him in the car. I didn't think he was doing whatever he was to have a traffic stop, but he gave me the phone number. This is the car. This is the license plate. This is the person. This is the video. It just connects all those things together. Because when you have a cell phone, you have to prove whose hand the phone is in. It's not enough just to have the phone. This goes a long way of proving whose hand the phone is in and when. Rob makes a good point. People have been questioning the investigation and criticized it for moving too slow. In my experience, a month is not slow. I think people are tainted by TV. And this PCA is pretty clear that they were doing their work. They were doing a lot of work, and getting cell phone returns and search warrants. These are search warrants on search warrants on search warrants. All of those things take time. But again, that's what we've been saying from the beginning of, hey, these things take time. I'd rather have a slow and thorough investigation than a fast, messy one any day of the week. Further analysis of the cell phone data provided showed that the phone utilized cellular resources on November 13th, consistent with the phone traveling from Pullman to Idaho via Highway 195 at approximately 12:36 p.m. The phone utilized resources that provide coverage to Kate's Cup of Joe coffee stand located at 810 Port Drive, Clarkston, Washington. Surveillance footage from the U.S. Chef's store located at 820 Port Drive, Clarkson, adjacent to Kate's Cup of Joe, showed the white Elantra consistent with subject vehicle 1 drive past the Cup of Joe at the time consistent. So again, the phone and the car moving together and external evidence, video evidence showing it. This is very thorough. At approximately 12:46 p.m., the phone utilized the cellular data in the area of Albert. They are pulling video from fucking everywhere. Of the Albertsons grocery store at 400 Bridge Street in Clarkston, Washington. Surveillance footage obtained from Albertsons showed him exit the white Elantra consistent with the suspect vehicle. He's in the grocery store parking lot where his phone is pinging, getting out of the car on video. I mean, now I'm starting to agree with the chat. This is the type of case the feds would take. There's video for lots of it. Feds like video. At approximately 12:49 p.m., interior surveillance, I bet you they're good surveillance because grocery stores and places like they have very good surveillance. Internal surveillance cameras showed him walk through the store, purchase unknown items at checkout, and leave at approximately 1:04 p.m. His path of travel is depicted below on the map. A lot of video. Additional analysis of the records for the phone indicate that between approximately 5:32 and 5:36, the phone was in Johnson, Idaho. The phone then stops reporting to the network at 5:36 to 8:30 p.m. That's consistent with the phone being in an area that the phone traveled in the hours immediately following the suspected time the homicides occurred. Interesting. This is consistent with the phone being in the area that the phone traveled in the hours immediately following the suspected time. I'm going to read that again. It shows that between 5:32 and 5:36, the phone utilized resources to provide coverage in Johnston, Idaho. The phone then stops reporting to the network from 5:36 to 8:30 p.m. This is consistent with the phone being in the area that the phone traveled in. I have some questions about that, but I'm gonna keep the speculation in my brain and keep going. Because I don't know how they know that. It seems like they're implying that it might have been a test run of the driving path. Anyway, keep reading. On December 27th, Pennsylvania agents recovered trash. Your DNA is on a lot of shit, people. On December 27th, Pennsylvania agents recovered trash from defendant's family residence. The evidence was sent to the Idaho State Lab for testing. On December 28th, the Idaho State Lab reported that a DNA profile obtained from the trash and the DNA profile obtained from the sheath identified a male as not being excluded as the biological father of suspect profile. So possibly dad's. There was a lot of speculation about whether there was familial DNA in this case. And they're saying, look, this is his family house. This is where the cell phone was registered. This is where the car was previously registered. And we went to that location and we got shit out of the trash and we tested it for DNA. And it is a sample that might have been the father of the person who had the sheath, which for a probable cause declaration is quite a lot of information because they already have some DNA back. And when the defendant was arrested, they would have taken his DNA and they are probably going to run that. So they will probably, if this is the defendant, they will probably be able to DNA match what was on the sheath in the murder scene and then have this defendant's DNA in this crime scene on a knife sheath when all 4 victims were stabbed. At least 99.9998 of the male population would be expected to be excluded from the possibility of being the suspect's biological father based on the information I'm requesting an arrest warrant issue for the defendant for burglary and 4 counts of murder. And then this is the is this the order that they're charged in? I wonder if the order that they're charged in is the same order that they put this in. So count 2 is Madison, count 3 is Kaylee, count 4 is Xana, count 5 is Ethan. So the order of the charging document is the same order that the officers put it in. And then this is signed on December 29th. And that is the probable cause affidavit. That's quite a lot of information that's in there. It is not it's chilling information, but thankfully not super graphic information, but it's sad. I want to go pull up that traffic stop real quick and look at the license plate because I noted that the license plate was visible and I was like, oh, the license plate's very visible. And then I was interested in going and looking at more of that. So let me go pull that video real quick and we'll look at it together. That is on Bryan Enton's Twitter is where I'm pulling that from. There was a family statement after the Kohberger hearing. We can go look for that in a minute, but I want to get to questions. So that's the second traffic stop. There's the first traffic stop. Okay. So I'm going to pull up this first traffic stop from Bryan. That was loud as fuck in my ears from Bryan Enton's Twitter. I just scared the shit out of myself. All right, let's pull this up together. We're going to look at this traffic stop just real quick, and then we're going to go to Q&A because hopefully that was helpful. So, all right, let's take a look. I'm going to back this up a little bit and freeze it. So that is a Washington plate. That is the same Washington plate that is in the that's what I wanted to see. This is the same Washington plate that's in the affidavit. So it looks like when he switched plates was when the plates were expiring. There's an explanation for that. The plates, the Pennsylvania plates were expiring and he switched them after the murders. But even though he switched them after the murders, there is a non-evasive explanation for that. So I mean, that ends up being kind of neutral, but it is there it is. So, and then this is the second traffic stop, Bryan, and has both of them on his Twitter. So there's an explanation for the plates changing. It's not going to matter all that much because they have a whole lot of evidence of the car and the cell phone movements. And then they're going to have that DNA. They have familial DNA on the father. I've seen cases tried on familial DNA only, but they have familial DNA. And they're going to have his DNA. They're going to have I imagine they had a warrant for his DNA when they did the arrest warrant in Pennsylvania and swapped him. So it's highly probable that will also be tested to match the sheath. If it doesn't match the sheath, that would be quite surprising. So I think it's highly probable. All right, now that we've looked at that license plate, let's go forward. This is a very good question. Could all this information taint a jury? Yeah, anyone who has followed all this information probably couldn't be on a jury. Because again, this is information that's not tested in court. It is signed under penalty of perjury by law enforcement, but it does not offer any other explanations. This is a probable cause declaration to get an arrest warrant for this person. So Yeah, that could be a problem, but that's something to be dealt with in voir dire way down the road if this even goes to trial. So, um, the courts are public, so we have to balance transparency and we have to balance not tainting a jury pool. So there is a gag order. This is probably the most information we will get for quite a while. Question, is his dad involved? I mean, there's no evidence of that at this point. Um, there's no evidence to suggest his dad knew. They were trying to track down if this defendant was this defendant. That's why they went through the trash. Let's see what day. Let's answer a few questions with this. Oh, no. We're going to answer I didn't roll the questions. I didn't roll our questions bumper, and I like it. And I haven't rolled it in a while because I've talked so fucking much that we haven't gotten to questions. So we're going to palate cleanse and roll the bumper before I pull this up. It's time to fact around and find out. Okay, so in answering this question, we have no evidence of that, and I don't want to speculate on that. It is just perfectly likely, or I shouldn't say perfectly, that's not the right word. It is absolutely likely that his parents had planned this trip over the winter holidays to go pick up their son and drive him back to Pennsylvania. And that pre planned trip, he might have pre planned it for nefarious purposes, but his parents might have been like, this is our PhD student coming home for the holidays. So there's nothing to me to indicate that his parents knew of anything going on, had reason to suspect anything going on. I'm not going to speculate that they had anything to do with that. I know people look for other connections. I'm not saying that you are, but people look for other connections. I don't think there is any reason to speculate about that. It's interesting that, well, when police walk up to the car, the windows are often down. It would be interesting to know more about the condition of the car and whether anything about the condition of the car would rise someone's suspicions. But we will maybe learn that if this goes to trial, maybe not. Um, we also don't know if this defendant ditched clothes and stuff after this event. What might have been in the car, what the state of the car might have been. This is a quadruple homicide, so there are going to be traces of things. What I want to see is the day they pulled the trash, um, and the day he was traveling. I want to see if they were pulling the trash thinking that he was already in Pennsylvania. So this is December 22nd is when 27th. So this is 2 days before this warrant is issued. I think that he was already in Pennsylvania by then, but we will know based on earlier in the warrant, it says when he arrived or when his car was pinged in Pennsylvania, but that's way earlier in this warrant when they talk about the car driving state to state. So let me go through and look at that. So they're pulling the trash probably because they think he's in Pennsylvania to see if they get his DNA. But the male DNA that they got, it looks like was his dad. It's very hard to determine from trash whose might be what if you have multiple people living in a residence. So let's see when we get to the vehicle information. That's vehicle. That's vehicle. Where is the vehicle being in Pennsylvania? Because it went to Colorado. That's what I'm looking for. Is the area of this where they talk about the plate being here we go. So on December 16th, it's in Pennsylvania. So as they're tying this together, this car is seen in Pennsylvania 10 days before they go and pull anything out of the trash. I imagine they were not looking for his father, that they were looking for that they were trying to find his DNA and they found familial DNA instead. Because again, when you're digging through the trash, sometimes you don't know what you are going to get. So Valerie is saying they did have a warrant for DNA. I imagine that they did. So jury is going to be hard. Yeah, this is a small area. It is going to be hard if this goes to trial. So nope, said I'm confused if his plates are expiring and he's supposed to be living in Washington. He just started his PhD. Why register them in Pennsylvania? Can you do that? This is inversed. His Pennsylvania plates were expiring. He was starting his PhD. He had done his undergrad in Pennsylvania. So he was a semester in Washington. So that's why he's registering for them for the first time in Washington is what it seems. So A neighbor's camera picked up whimpering and crying from that far away. How loud was it? They in this search warrant, actually not search warrant, in this probable cause affidavit said how close it was, and it was not, it was in close proximity. Let me pull that part up. Let's see. That's the truck. At 4:17 a.m., a residence immediately northwest. Distorted sound of voices or a whimper followed by a loud thud. A dog could be heard barking. The security camera is less than 50 feet away from the west wall. So within 50 feet in quiet of night. So Amy Van Dyken, good to see you, friend. Thank you for breaking it down. You're welcome. I hope that it's helpful in understanding. I also think that it's helpful in just breaking down kind of where there are questions, where there's more information, how this information is going to be used to build a prosecution, where there are things that the defense will hit on. And again, we haven't heard the defense's side. This is just law enforcement side. This is a sworn affidavit by law enforcement. This is one side. So the government bears the burden of proof, and the defense gets to try to point out probable, reasonable doubt. If this goes to trial, will it go to trial? Who knows? Could it be a plea deal? It could. How likely do you think he is to plea? I don't know. I don't know if that will. I don't know if the prosecutors will even be willing to take the death penalty off the table to plea in this case. They might not. They might be like, no. If you want to plea open to the judge, because you can plead to the judge. You can say to the judge, I'd like to plead guilty. Sentence me. You can do that. You can remove the prosecutor from that equation. The prosecutors might be unwilling. But then again, the surviving roommates and the families might be like, you know what? The best interest of everyone's well-being. If he wants to plead to 4 counts of murder and 4 consecutive life without the possibility of parole, do we need all of this unearthed through a court process? Do we need that for closure, or is that just going to be more traumatic? But that also is the defendant's right. He can say, no, put it up and let's see what you got. Let's put it in front of a jury. So those are large considerations. So there's a lot. We're a long way from that. We've got to get through a preliminary hearing first. Do I think he'll plead before a preliminary hearing? I think that's highly unlikely. Question: do you think he could have been hiding in the home? I don't have enough information here to speculate on that. We don't have any information about an ingress or egress from the home. I also don't know, with this many roommates, if this is a home that's left unlocked, that is a possibility. He was in the area quite a lot, it seems. So could he have been figuring out those things? It's possible. There's not enough information here to say one way or the other. If that's information that's known, then I am sure that is information that they are holding on to. So, let's see. Odd a criminologist PhD student would commit a murder while leaving behind so much evidence. Not really. I mean, I think there's a big difference between thinking that you're interested in something and knowing something and doing something. I mean, I think, I don't know. I think there's always a possibility that people who want to intellectualize something and be like, oh, it could be this, it could be that. Actually doing something this horrific is not something that you're going to be able to execute perfectly when you kill 4 people. There's going to always be evidence. Let's see. All right. Do you think this is a death penalty case based on what we have now? I don't know what this district attorney's office will want to do. I don't know how the victims' families feel about it. Could they seek the death penalty in a quadruple homicide without people being like, really, you're doing that? Yes, they absolutely could. I don't think it would raise eyebrows. I think people would understand why they're making that choice. Could I see them also choosing not to do that if it really isn't within the wishes of the victims' families? Yes, I could see them doing that too. So, it's just, I don't know this DA's office. I don't know this DA. I don't know how the victims' families feel about it, and all those considerations need to be taken into consideration when making that decision. So I just don't know. Why didn't the judge include the PCD in the gag order? These are public documents in court. I think it would have been a bit overreaching because these aren't people sharing information. This is a public court document. So we have open courts. Jessica asked what I think a lot of people are asking. Do we know if he knew the victims? Not from this probable cause determination. We know that he was in the area 12 times. Do we know if he was in the area um, as an individual who's friendly? No. Um, what we do know that leans towards probably not, depending on these roommates, is we know that the surviving roommate saw the bushy eyebrows and the face covering and described him as if someone that they had never seen before. If you have seen somebody before, you would generally not say they have bushy eyebrows in this build. You would say that's this person. Um, I've had a case like that where the defendant didn't know that they were known, but they had been known by other high school kids in the area because of their sports prowess. And so the kids all got robbed and they were like, well, it was this person. We know them. Like we know that person. They don't know that we know them, but we know who they are. It's like when you see someone that you see someone on the street that you recognize and you're like, oh my God, that's, that's that YouTuber or whatever. So if it's somebody that they had known, is it likely that they would get this description more like an unknown person leaving the house versus I recognize that dude? So if we have to balance the probabilities, I think it's less probable that the roommates knew who he was and more probable that he knew who they were, if that makes sense. Um, could the knife have belonged to his dad? I mean, anything is possible. I don't know if these are things you can buy online or if they're things you can only get from the Marines. If if his dad was a Marine, which I don't have knowledge of, um, borrowing something that can be traced back to your family to commit a quadruple homicide seems like a terrible idea. So, with that, uh, Sadie said his sister lived next door to the victims. I have no knowledge of that. I have no information of that, but if that is true, I would hope to have seen that information in the probable cause declaration because it puts a bit of doubt into, well, if he's in the area, if his cell phone's pinging, there's a reason he's in that area if somebody is there. So I have no knowledge of that, but I would hope that that would be disclosed in the probable cause. So what are the chances it goes to trial? Too early to tell. I will reassess after a preliminary hearing and see. He's barely been arrested and appeared in court once. We're very, very early in a long process. I heard somewhere that reporters would be allowed in the courtroom. Is this confirmed? They were there today, and there was cameras. I covered that court hearing early in this stream. So, yep. Let me see. Question, was the genealogy thing just misinformation? There's a lot of misinformation. I don't know what people were saying, but this is familial DNA, but it's familial DNA from trash. So again, this is why we wait till we have official information, because now we know that they were going through the trash in a time when this defendant was living there, probably looking for his DNA, and what they found was something with his father's DNA. So, did I miss how they zeroed in on the white Elantra? Was it always from video footage? Yes, ain't so plain Jane. Video video footage in the area at the time of the crime. And as my mentor at the DA's office would always say, the crime, the crime, the crime, and the defendant's connection to the crime. These are the things you need to know the most. These are the things you need to remind the jury of. And this is your simple formula for being a good trial attorney. I mean, unless you're a defense attorney, and then it would be the opposite, the crime, the crime, the crime, and somebody else did the crime, not this defendant. Jordan said, do not blame the surviving roommate for the deaths of her friends. No. 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 The surviving roommate has been through trauma. The person that did this is the person who did this, not the surviving roommate. We don't have all of the information. We have enough information for them to arrest this defendant and hold him past preliminary hearing to let this court process play out. We don't know any more than that. Lots of grace is needed for the surviving roommates and expected by me. The internet is not always kind, but I think I mentioned it when we went through this, how people respond to a traumatic event and what transpired between 4 a.m. and the 911 call. I have questions too, but I'm going to say I have questions. There are questions there. There are questions that are unanswered, and we will see what continues to come out about this case, if that helps. Why did the news report all roommates were sleeping when the murders occurred? Per the affidavit, we now know that that's not true given witness statement. I don't know why the news does the things that they do. I think they were going off the information that they had at the time that they had it, and they probably made some assumptions, like everyone, and myself included, made some assumptions off of that later in the morning 911 call, assuming that, okay, well, you've got college kids getting back early in the morning after being out at a frat house and being out at another location. It's reasonable that they were asleep. But should that be reported as anything more than this is what we think happened? No, because you don't know. And you don't know until you know. So, Christina said, have you looked into the case of the tarot reader being sued for defamation? I pulled it yesterday. We started to talk about it yesterday. We haven't gotten into all of it. Can judge ask to be on certain cases? Generally not. Most jurisdictions have a system for how cases get assigned, and it just depends on how many judges there are in a particular location, but they have a system for how things get assigned. You're not going to have a judge be like, I want that one. What you can have is judges say, I cannot, I am recusing myself from this case because I know parties involved. Or if you get like, I don't know, there was a judge in LA that had a lot of stock in one of the car manufacturers and was like, I am not doing like the lemon law cases on this particular vehicle because I own a lot of stock in that vehicle and I don't want to appear biased, things like that. Judges can nope off of cases, but generally can't request a particular case. So, but all jurisdictions vary. What is the basis for the burglary charge if nothing was taken? It is breaking with the intent to commit a crime, and we went through the arraignment, and the intent here was murder. So they broke into the home with the intention to commit a crime, that crime being murder. So it doesn't have to be theft. Often it's theft, but it doesn't have to be. It doesn't have to be theft. So that is why. That's a good question, Seamus. Question: is there a current theory on his motive? No. And we haven't seen any. So I know it might look like a stalking case. I'm not there yet. I'm not there on whether. So the behavior that can be interpreted as stalking, I don't know if that is stalking or if that's canvassing a crime location. Stalking has some different implications versus this is canvassing a bank. You wouldn't call it stalking if you're trying to rob a bank and you're going around the bank and trying to figure out the security in the bank. You're planning. So I don't know. I don't know enough we don't know how he knew, if he knew these victims. We don't know why he was in that area. We can only speculate. We know that he was in the area a lot. We don't know if he was in other areas where they were. We just don't have enough information to know what the motive was. We know a lot of information now about how this went down and how he was caught. The thing that we need to keep in mind is we don't always know motive. We don't always know motive. If this doesn't go to trial, we might never know motive. And that is a really unsettling thing because as humans, our brains really like to understand the why. Why did this happen? How did this happen? Why did these four college students lose their lives in such a horrific way? Why? We want to know why. And we might not know. And that is deeply, deeply frustrating, but we just might not know. So I'm waiting to see what the information we get tells us. What does a defense attorney need to do to qualify to fight a death penalty case? Thank you. It depends on the jurisdiction, but there are generally a certain number of years of experience. Natalie Lawyer Chick would probably know this in more detail than me, but from best memory, certain number of years experience, you generally need to co-chair a death penalty case or more. You will definitely have needed to try murder cases before. You need to have the requisite experience, and there are generally some classes that you would do to be qualified as a death penalty attorney. Does the PCA indicate if his license plate in any of the video footage from the night of the murders? It didn't say that specifically. It talked about when they got license plate. I don't know if they have any license plate reader hits around there, and I wouldn't expect them to because they're not There's nothing like they said that he's like there's a red light camera or anything. If there is, we might see it later. So, we might see it later. So let's see. Um, question: why is Daddy flying out to drive him home? I don't know. I don't know, but just from my own life experience, I mean, my dad has flown to like drive my brother and the vehicles back from state to state. So I don't know if your kid is driving cross country and you want to spend time, I can see a parent saying, "Hey, okay, if you're driving home for the holidays and you want to drive across the country, I'll come out and go with you." I can it might just be the simplest explanation. I'm not reading anything nefarious into it because there's no evidence that leads me there at this point. It might just simply have been he's driving his car home for the holidays because he wants to drive his car home for the holidays. So in one of those traffic stops, the police are like, "What, you afraid of flying?" However, flying this holiday season was fucking awful. So it could just be that. Um, it could just be that. So it yeah, I'm not reading into his parents. We don't know his parents might have been caught as off guard by all of this, and I think that's probably likely, caught as off guard by all of this as everyone else is. And I imagine this is they're also walking through the unimaginable. They're walking through, um, their kid facing for death penalty murders. So, I just we don't know, and I try to give grace. I try to give grace. The family wants the DP according to the interview. Okay, well then we know how they feel on that. So I really do. I try unless we have information that shows that people are involved. I really, really try to reserve judgment on that and say that you know, especially when you get into older adults, a PhD student is an adult that has free will, has their own life. And do I think parents know everything their kids are up to? No. God, if my parents knew everything I was up to, Mom, I know you don't watch my live streams. There are things you just never need to know. It's fine. Um, I just don't think I don't know. We don't I'm just not reading anything into that. Because I don't there's nothing that leads me in that direction, if that makes sense. Now I feel like I'm over explaining. Hey Joe said I drove my kid to LA and flew back. I mean, I can see doing that for my kid too. Absolutely. So question: if things go to trial, will he have to testify or could he waive? The defendant in a criminal case in the US, the defendant has an absolute right not to testify, and it cannot be commented on. The defense attorney or the prosecutors in the Rittenhouse case stepped on that a bit. It really pissed me off the day that happened in court. It is an absolute right. It cannot be commented on like, "Oh, well, if so-and-so's so innocent, if there's so much doubt, why don't we hear from them?" No. The right to remain silent means that it cannot be used against you, meaning an innocent person would testify. Nope. The right to remain silent means it cannot be used against you that you have chosen to shut the fuck up. So, no, he cannot be forced to testify. He can choose not to. He could choose to testify. I don't think that's a good idea, but he can choose to or not to. So question: does criminology class teach everything? No. Um, well, I didn't do academic criminology, so I am not the best person to answer this, but there are people who know all the ins and outs of how to commit crime and how to not commit crime. I don't think the knowledge of how to better get away with crime and like literally how to get away with murder and how not to helps because there's a lot of people that even if they have that knowledge aren't going to murder people on a moral level. So, no, I don't think things are held back. When I say I don't want to teach people how to better crime, it's just that's within my own compass that I don't want to teach people how to crime better. It's not like hey, this is not legal advice, but you might want to turn off your cell phone. We're trying not to do that. Or hey, this is not legal advice, but I will tell people you have the absolute right to remain silent. It can't be used against you. And if you don't exercise that right, it absolutely will be used against you. If this case doesn't go to trial, if he pleads guilty, what happens then? Nothing. He pleads guilty, he gets sentenced, and then hopefully everyone can start to move on, which is also I don't know how parents move on. Like, I don't know. My heart goes out to them. Then it's done. I don't know whether it being done fast is better. Maybe it is. Maybe it feels anticlimactic. I don't know. It I don't know. It can. So, so we'll see. We have a lot of super chats. I'm going to try to intersperse them. I always try to answer questions both with the super chats that support the channel because we're absolutely not monetizing this video. I try to weave them in so we make sure that we did that. Question: what would your defense strategy be if you were appointed as his lawyer? Find out as much fucking information as possible. That would be the first thing. Beyond that, I don't know. I haven't really thought about it much, but I would want to know. Would you represent him or refuse with what you know? I didn't choose to be a defense attorney because I don't have a poker face. So which also got me in trouble as a DA. I had judges be like, "Miss Baker, your face." I'm like, I'm much better suited, I think, for being a YouTuber because my face does the things. But I didn't choose to be a defense attorney because I don't know. And again, being a DA was maybe I loved being a DA, but I'm also deeply empathetic, so I took on quite a lot of stuff. I don't know. I don't know how I would feel, but what I do know from the defense attorneys that that I know and I'm lucky to call friends and that I respect tremendously is that it doesn't really matter to them what the person did. Everyone deserves a defense, and they do. Everyone deserves a defense and a good defense. And that can be really difficult when the crimes are really horrific. Not to sound callous, I have seen this is a quadruple homicide. This is the worst thing that has ever happened with these victims. Have I seen cases that are worse? Yes. Do they immediately come to mind when I start talking about stuff like this? Yes. But they all need a defense attorney. And so having a good attorney who can say, I am here to make sure that your rights are not trampled is a very, very specific job that takes people with a fortitude to be able to say, look, uh, God will judge you, some other power, not me. I am not here to judge you. I am here to make sure that your rights are preserved and you get a fair trial. And if you are not the one that did this, that we fight like hell to make sure that you are exonerated. Is that a job I chose to do? No. If I chose that job, would I represent a defendant that was put before me? I would like to think that I would, because that is the job that I chose, and that is what I chose to do. Did I choose to do that? No. Do I think I would be good at that? No. No, I don't. I don't think I would have been good at that at all. I think I'm much better suited. Personally, I think I'm better suited for this. I like doing a podcast. I like being on the internet. I like explaining the law to y'all. I really do. Do I miss being in court? Sometimes. Did I hate not having to say, what the fuck is this shit when I was in closing arguments? Yeah, it was really constraining. I didn't like it. Wintry Witch said, even when I say nothing, you can read the subtitles on my face. Me. I like doing this. And I think I'm better for this. That's why I said PD and Taylor has a tough job ahead if it goes to trial. Yes. And yes, a tough job ahead. But also the thing that I think one of the things that bothers me the most is when people try to come for attorneys to be like, how could you represent this person? It's literally your job as an attorney. I didn't like it in the last Supreme Court hearings. It's like, how could this attorney represent those people? That is your job. So looking at someone being like, how could you represent them? They're doing their job. We should ask if attorneys are doing their jobs ethically, not what kind of defendants they are representing. It is their job. It's different in civil than in criminal. You have a little bit more choice, but in criminal, especially when you look at a public defender or an alternate public defender, they're assigned the cases that they're assigned, and that is their job. And they are a needed part of the system. And the system doesn't work well without both parts. It's an adversarial system, and you need both sides of the system to work. So Allison said, I was once told by my boss to fix my face because I was on a call with difficult people and apparently didn't have a poker face. Question: does the state of Pennsylvania conduct the search of the vehicle now since it was confiscated there? Deb, this is interjurisdictional stuff that I was never law enforcement. I was just a DA. I imagine based on the FBI's involvement in this case that the FBI is probably processing the vehicle. That is an assumption I am making. I imagine that they are doing that locally in collaboration and communication with the lead agency in Idaho, but the FBI is already involved. They're going to have a location in Pennsylvania somewhere where they can do this. So I imagine that that is being done, if not by the FBI, by other law enforcement in connection. So this is a collaborative effort, but I imagine they didn't. I imagine that they didn't transport the car back to Idaho to do that. I think they could probably do that in Pennsylvania, unless they needed to transport it somewhere where they have a good garage. But they are going to, when we come to the car, they are going to take that car completely apart and document every part of the process. And now there's a defense attorney involved, and they're going to make sure that it is well photographed, possibly videoed. They are going to take out everything. They are going to pull the car down to its bolts. They are going to go over all of the fabrics in the car. They are going to take out seats. It is going to take them time to go through this car. But they are going to go through this car to find anything. And they are going to first, I think, be looking for anything that connects the victims to the vehicle. I think that's the first thing that they will be looking for. Any trace matter. I mean, this is a quadruple homicide stabbing. This defendant got back in the car, it seems, based on this probable cause and fled. It is reasonable to believe that there is something left behind in that vehicle, and they are going to be determined to find it because that will tie this defendant and this car back there. All right. Jennifer said, I had a choir director jokingly call me Jen with the face because I always made a face when I sang a mistake. I feel your pain. I mean, it's hard. Sometimes it's hard to control your face. I was better practiced at it, but I was not great at it, especially when I worked retail. Was I great at working retail? It's like, no. Because if somebody's complaining to me about something stupid, my face tends to make that. Are you really complaining to me about this something stupid face? Oh, retail. At 9:30 a.m. back to the scene of the crime. Holy shit, I forgot my knife sheath. Very possible. I visited a friend who went to WSU and we went to a Moscow party. Very, very common. It sounds like they're very close in space. I mean, when I was at UMass Amherst, all the colleges in Amherst are kind of like right there together and we would see each other. It's not uncommon. Anne said there's a good TEDx talk from parents of a Columbine shooter that explains how they felt. That would be very interesting to see. Question, did you ever refuse to represent someone? So I was a district attorney. I was not representing anyone but the people of the state of California. Did I have cases that I advocated should not be cases? Yes, all the time. Did I have cases that I thought should not be prosecuted? Yes, all the time. The thing about being a prosecutor is you are in a position where you can advocate for those things to not be prosecuted. And that having that level of like, this shouldn't happen. As a prosecutor, you can make that decision. As a defense attorney, you're kind of stuck with what the prosecutors decide, and then you have to fight with them on it. Does the gag order prevent his lawyer from giving statements right now? Yes. Is his lawyer giving statements right now? Hold on. To the internet, to the interweb, to the interwebs. Hold on. Oh my God, I almost took a job at UMass Amherst. I really liked my time at UMass Amherst. We're going to the internet. I'm going to look. Okay. First of all, I trust the chat. So I'm going to let the chat tell me if there's an interview. I don't think there is, but I'm going to let the chat, but I'm going to tell you exactly what the order says. We went over this yesterday. We'll just go over it real quick. And then we will get to a few more questions. All right. This is the non-dissemination order, aka a gag order. Let's see. It is ordered that the parties to the above entitled action, including investigators, law enforcement personnel, attorneys, and agents of the prosecuting attorney or defense attorney. So all the attorneys and any agents thereof, any law enforcement, any investigators, this is basically everyone except family members, are prohibited from making any extrajudicial statements. This means not in court statements not in court. written or oral. This means even if the defense attorney is walking out of the courthouse and all of the news reporters are like, hey, blah, 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 no comment. They'll probably just keep walking. Other than a quotation from or reference to, without comment, the public records of this case. See the probable cause declaration. The next hearing's on this date. Other than a quotation from or reference to, without comment, which means they'll probably say nothing, the public records of this case. So no, they can't. Carla, thank you. It was the victim's family's attorney. They can make statements because they're not the attorneys on this case. The victim's families can make statements. Their attorneys can make statements, unless this is modified. Because right now, this is investigators, law enforcement, attorneys, but this means attorneys involved in this case, agents of the prosecuting attorney or defense attorney. So this does not extend to the victim's families. So that is what is covered. Flickr says, asking out of curiosity, have you heard of Gonzalez versus Google? Yes, I touched on it in a quick bits. I have not had a chance to read all of the latest briefings, but I will. It's one of the few Supreme Court cases that I'm keeping an eye on. Question, do you think the defense attorney might request a change of venue for jury selection? I think we're a long way away from that. So we'll see. I think we're a long way away from that. Always possible. They don't have to do that now. Questions, can the surviving witnesses make statements? I assume you mean the surviving roommates. They are not covered specifically by this gag order. However, because they are not investigators, parties, law enforcement personnel, attorneys, agents of the prosecutors, agents of the defense. They are witnesses. So it would be a not great idea for them to make any comments at all. And I think it would actually probably be a relief to them to be able to say that they can't. I imagine that they don't want to. And these are making public comments. That doesn't stop them from talking to therapists, hopefully, immediately. Question, do you think now that they have his DNA, now they might link him to other murders that are unsolved? I have no idea. None at all. But it's this is, again, assuming that his DNA wasn't in the system before, which I think is a fair assumption, because if his DNA was in the system before, when they had it off the sheath, they wouldn't have been digging through the trash. So it's fair to assume his DNA was not previously in the system. Is that possible? Anything's possible. So let's see. Question, could Maddie have been the initial target instead of Kaylee since she is first on the criminal complaint? If Kaylee was the target, wouldn't she have been listed first? No. I think that the criminal complaint, now that we've been through all of the affidavit, it listed them in the order they were in the affidavit. Why are they listed that order in the affidavit? Unknown, but I'm not going to read anything into the way they were listed in the affidavit. They weren't listed. Were they listed alphabetically? This is why I always tried to list things alphabetically, because it made sense to me, but no, these aren't alphabetical. So I don't know. It might have just been in the order that the officer mentioned them. Well, let's go look together, because I don't want to read too much into it and say this person was a target versus that person. We don't have any information about that other than that the location was visited, or the vicinity of the location, more than 12 times. But this might just be in the order that the officer talked about them earlier in. So this order, I have to make a note. This is why I do things on paper, so I can flip back and forth. Let's see. This is, I already have it written down because this is in the order that they're charged, and they're charged in the order that they're listed here. So I imagine that this is the order that they're listed at the top of the document when they go through the house. Nope. So the first listing here is Xana, then Ethan, then Kaylee, and then Madison. So I don't know. Is this reverse order? Because it's Madison, then Kaylee, then Xana, then Ethan. No, in no particular order. So why they're in that order, I don't know. Am I going to read anything into it? No. Sophie says, I have a criminology bachelor's and master's. It's strictly the study of criminal MOs and societal behaviors towards crime. Thank you, Sophie. I appreciate that. I didn't imagine studying criminology. Like if you're studying forensics, I imagine you would be studying forensics, like crime scene forensics are different than criminology. Um, so thank you. It seems that criminology is more in the realm of sociology to me, but again, I was a boring political science major, like everybody else. If I could go back and do it again, though, I would absolutely do philosophy and rhetoric. Um, that's what I would do. So let's see. Question: did the defense attorney know what was in the affidavit prior to the court hearing today? The defense attorney would have probably been, this is again, I don't know. The defense attorney probably would have had the opportunity to have that when the defendant was served it and when the defense attorney came on. Would that have been shortly before court? Yes, they would have also probably had the charging document. Not that it matters too much for court today, because it was literally just the charging document and the arraignment. Question: can he be charged for both state and federal crimes? Yes, if the crimes are separate and apart. We see this a lot in weapons cases where you can be charged with a crime for certain types of weapons in state and federal. Do I think that'll happen in this case? No. So, Andrea said it's easier to control the mouth than the eyes. I mean, fair enough. It's easier for me to shut my mouth than control my face. What is the process if they need to move jurisdiction to a bigger county? Well, there's kind of two parts to this. Excuse me. Excuse my nose. I'm sorry. Give me 30 seconds. I have to blow my nose. Well, that was delightful. Thank you, everybody. Sorry for the Emily is still sick and congested break. We're gonna just let the music play out. Question: what is the process if they need to move the jurisdiction? So there's a couple answers to this. A couple answers to this. First, they could expand where they pull the jury pool from without needing to move to another jurisdiction. So they could say, hey, we need more jurors. We need to expand the jury pool. So if they say this court has a 17-mile radius from the courthouse, they could extend it to like a 30-mile radius or whatever. So they could extend where they normally pull the jury pool from. That's possible. If they need to change the venue to another location, you need to make motions in court and do all of that. Are we a far way away from that? Yes. Question: wasn't that an abnormally long affidavit? I mean, it was very thorough. It is a quadruple homicide, and they did rely on a lot of things to tie the defendant to it. I think it was, I think they really didn't want to put too little in and have an issue with the affidavit being quashed or something. I think this is making sure that they are covered, and I think we're seeing an abundance of caution, perhaps. So thank you. I appreciate that you like the music. I love the bumpers. I'm going to add some more music bumpers and I've been meaning to add a million things to my sound deck and I have not done it. You know, we
basically just stick with the voice changer and, you know, if the wand of justice noise. That's what we stick to.
But there's lots of other things. I don't get to all of them. So, Idaho isn't going to move the trial. I mean, they could move it into another county in Idaho. I don't know if they will. Please use that music every time you blow your nose. I will definitely use it every time we need to take a break. I enjoy that bumper music. Question: when will he plead guilty or not guilty? He didn't enter a plea today at the arraignment. Normally you enter a not guilty plea. He just was arraigned with the hey, you understand these are the charges against you. So I don't know what their process is for that. So I don't know. So hopefully that is helpful. I know, Tech, I definitely need to add the gavel sound. I know I do. Donna said I have a black belt and eye rolling. I mean, so many of us do. So You like the bumper booger music? Thank you. We just needed. We just needed. I tested negative for every alphabet number of flu, for all of the other things. So I just have yuck. So cold. I just have congested things. And I've been talking for a very long time and it's just wiggled it out. That defamation case for the tarot card girl is upcoming. Yeah, we're gonna have to do that on a separate stream. But I am here. I didn't go to New York for Jen Shaw's sentencing. That's tomorrow. So I will probably cover that on Tuesday. So yeah, I will probably talk about that later. Anna P, thank you for the generous super chat. I appreciate it. Y'all, look, we get to be independent content creators by community support. Sometimes that makes the mainstream media salty. I don't mind their salt. So we love being supported by y'all and maintaining this community. It's what matters the most to me is the law nerds. For him being a PhD candidate on technology, he was a criminology PhD candidate, but he had an undergrad dealing with the other stuff, if that makes sense. He sure was dumb about his own tracks. I mean, you never know how people are going to react. You never know what people are going to do, and you never know what people are thinking. I think sometimes people think they're smarter than they are. I mean, I dealt with a lot of fraud cases, and I really liked dealing with fraud cases. Not every prosecutor wants to deal with fraud cases. They're different. I liked fraud cases, and fraud defendants definitely thought they were smarter than everybody else in the room. So dealing with clever defendants is always an interesting thing. So I think arrogance is probably fair. So the arrogance of thinking he could help local law enforcement with technology and investigations. I think there's arrogance and probably curiosity there, but it is. Please respect surviving victims. They are not to blame. They had no idea what had happened. Shock, fear, freezing is a common reaction. Thank you for the super chat. Can the PD get knife sheath thrown out as evidence? I mean, not based on anything I've seen. Can evidence be thrown out in cases? Yes. But this was found at a crime scene. I don't see any grounds for that. So I don't know, Christina, what would cause that? There has to be a reason. And I don't see a reason at this point. So let's see. Not overly fond of Kohberger. I mean, fair, same. DoorDash delivered at 4:17 a.m. Interesting because in the affidavit it says 4. That's definitely an interesting timing, and I'm sure that they will have that all pinned down. But the timing on that is interesting. So wanting to find out what's going on, like PADA said, I think there's a lot of wanting to find out what's going on. This was a very thorough affidavit. The traffic stop shows Pennsylvania license plates. The traffic stop showed Washington license plates. We looked at it. Am I wrong? Did I forget? Twitter also shows Jen Shaw on the way. This is why I can't go on Twitter to pull things up because then I get distracted. Hold on. And I don't want to get distracted. Then we end up down rabbit holes. The members know exactly what that's like. When we start talking about things, let's see. The first traffic stop is the one that we pulled up earlier in the stream. I'm gonna mute it when I pull it up this time, but it was Washington plates. We're gonna do that one more time. So those are Washington plates. Mountains, red, blue. So I can't zoom that anymore. These are on Bryan Enton's Twitter. At Bryan, I think it's at Bryan, just Bryan Enton. So those are on his Twitter if you guys want to see them. But no, that is those are Washington plates. So and then he is stopped like 2 times on the same time. Question speculative. Are they checking his DNA towards other similar unsolved crimes? If he is in the system, once he goes into the system, will the system automatically pull things up? Yes. These investigators are not looking for more. They have their hands well full. These investigators aren't looking for more. These investigators are looking for a clean investigation and prosecution about this defendant. They might know with the prosecutor where there are gaps and where they want to fill those information. They are going to be solely focused on this and not looking for more. If his DNA is in the system, can it be checked against other DNA that's in the system that's a no? That happens. Will they be actively looking for that? Not unless they have reason to actively look for that. Does the gag order prevent his lawyer? Okay, we addressed that. So yes, the defense lawyer is gagged. Can you provide more info on why the gag order is in place? Because the judge said so. Can we speculate as to why the judge said so? Maybe. Do we think it's helpful? Probably. The judge is going to keep a tight rein on this case. There's been a lot that's gone on that's not ideal on social media in this case. So do we see the judge reining that in? Yes. Is it probably to also protect a jury pool? Yes. Is there a lot of information out? Yes. And we'll just see. So let us continue on. Let's see. Question. What do you think of BK mentioning the incident at U of Washington during both traffic stops on his way to Pennsylvania? I haven't thought too much about it. I thought it was interesting that this defendant was trying, I guess I have thought a little bit about it trying to talk about other things with the police officers. It seemed like he was trying to have them talk about a subject and not ask him a lot of questions. That's what it seemed like to me. And trying to relate to the officers about something that had happened that they maybe might be interested in. Salad Bar said, big hugs to the mods. You guys are doing great. It isn't going unnoticed or unappreciated. Yes, it was a little rough earlier. I think it's probably tampered down now. Thank you for the mods. Hopefully it has. Plea wasn't brought up, but probably because the defense just shot the. Oh, we are well in advance of a plea conversation. This is way too early for that. So, missed the purple heart by your name set. Oh no, I forgot to change it back. I was doing something. With media the other day, yesterday, and I changed it. It wasn't an intentional. I meant to put it back, but then I didn't expect I was going to be streaming quite this quickly today. So it will be back. It will be back. That was just, I changed it yesterday and forgot to change it back because when I went to go live today, I was still looking for that court hearing more quickly. So, and I don't know if I can do that streaming without screwing something up. So it will be back by the next stream. So, what is DoorDash? This is a fantastic question. I assume things that I shouldn't assume. DoorDash and Uber Eats are delivery services that go to food locations, pick up your food and bring it to you. So instead of a restaurant having a delivery service, these apps have a delivery service. So an Uber, a DoorDash, or what have you, you can use the app and order food from a restaurant, and then the driver goes and picks it up and brings it to your house. So it is fantastic. It is just fantastic. So food delivery, very, very helpful food delivery. We're going to keep going through some super chats. I'm late. When will this trial begin? Oh no, we are not even close. We are not even close. There's a long way to go before we even have a conversation about that. This judge might set a trial date, probably in 2023, or no, probably in 2024 if the judge sets a trial date. But the judge will set a preliminary hearing date after setting a status conference. So on the status conference date, might we know more? Yes, the status conference date is, when did the judge set the status conference? November 12th. So we're going date by date. When will this go to trial? It's going to be a while. The criminal justice moves slow. The Brooks case went to trial within a year, which was tremendously quick. So, Veronica said, Emily, does the order of the names that the judge stated in the deaths matter because it was not in alphabetical order? Hey, Trev, you're home from school. I'm streaming. What? Oh, yeah, the home edit's in the garage. All right. Is your dad's probably out picking up your brother? Good to see you. Okay. I'll let you know when I'm done streaming. All right, thanks, buddy. Sorry, my kiddo just got home from school. The order of the names is the order in the charging document. So each victim is their own count. So does it matter? That's how it's charged. And the names in the charging document are in the order that they're in at the end of the probable cause affidavit. So for whatever it matters, you can have a plate from one state and have it registered in a different state. It's an out-of-state registration. In some states, it's cheaper. Okay. If it was expiring, though, I imagine instead of going back to Pennsylvania, I don't know. I think this case is going to prompt a lot of I have questions. I think so too, and I think we will have questions. And there's always a balance. There's always a balance for me on, and I'm still learning this balance, and I'm still getting better at learning this balance. and the balance between these are all my questions and then making sure that there still is a sensitivity, because the lawyer side of the brain is more analytical, right? And sometimes analytical doesn't always acknowledge the feelings, and that can feel cold. And then the emotional side of me is trying to balance back those questions. So I try to process that with you all with mindfulness and compassion. It is not always perfect, but I definitely try to balance that, because like analytical questions and then questions that can feel cold, we don't want to, we try to balance them because it's hard. There are a lot of questions here, but this is beyond our own curiosity too. This is also dealing with 4 people who were murdered, dealing with witnesses who seemingly were confronted with the murder that night and lived. It's just so much. It's just so much. My kid's personal Uber driver, relate. My son's name is Trevor, but his nickname is Travis. Long story. Travis was going to be Trevor, but then was Travis. So we're in the same realm. Travis was going to be a Trevor, but then was a Travis. Emily, I keep hearing that they had partial DNA evidence. Is that because they had his father's? I don't refer to that as part. So I don't know who they are, but Catherine, I'm not referring to it as partial. It is familial DNA. So I don't, I don't know. I don't know why people would call it partial. It's familial for me. So, Jill R said the trauma of the survivors is heartbreaking. It is, and I think there will be time for questions to be answered. It's just, I guess maybe I'm used to the pace of this, and I'm used to the pace being slow. It's weird not being a DA anymore because you don't get all the questions answered the way you want to. Because when you're inside, you're working on the cases and you get you get to ask the questions and go have them answered. So it's weirder as an observer, but I'm used to the pacing of this. So this pacing doesn't seem slow to me. This seems actually on the faster side of normal. Like getting from a quadruple homicide in a small jurisdiction to an arrest within a month doesn't feel slow to me. It just doesn't. Like Ted Lasso, be curious, not judgmental. I think that's a fantastic way to frame it, and he said much better than I did, for sure. Carolyn said, "Why didn't the surviving roommate?" We don't know. We don't know, and we don't know. We don't know, and I'm sure the surviving roommate also might not know. And so I'm not going to speculate on what what they did, um, why they didn't. There's more information known here that we don't have, because this is just a probable cause declaration. So, is there ever a scenario in criminal case in which the defendant is compelled by the court to testify? No. No. Fifth Amendment. Fifth Amendment. Fifth Amendment. So, I meant the ones on his. Oh, I meant the ones on his way home for Christmas showed PA. Kathy, the ones on the way home for Christmas are the ones that we went through. Um, my understanding is the stop that we looked at is the stop from December 15th on his way to Washington. So this is, again, body cam video from Indiana State Troopers pulled over Bryan and his father in a white Hyundai as they drove from Washington to Pennsylvania. This is from December 15th. Oh, this is mute. So this is from December 15th, and we can see the date 12/15/2022. We can see the body cam information. These are Washington. So this is on his way home. Do states tend to retire license plates involved? I have involved/named in high profile crimes, or do they get back in? I have no idea how states decide to do. Literally no idea how states decide to do that. I just don't know. Thanks for covering. Hashtag shrimp fried rice for Hogue Law. Yes. I've been encouraged by the updates from Hogue Law. What years were you at Seattle U? I was at Seattle U. What was my first year of law school? 2002 to 2003. And then I transferred law schools when my husband took a job out of Washington. We were in California. He took a job in Washington. We went to Washington. And then he took a job back in California. And then we went back to California. So that. Will there ever be a transcript when he was pulled over? Will you be reading the transcript when he was pulled over? I didn't know there was a transcript. So if there is a transcript somewhere, I can cover it another day. I haven't seen that. And I don't know who made the transcript, but I will take a look. The U of I has a law school that's been around over 100 years. I think there is only one public defender covering the entire county. My wife almost applied for that position, but went to Boise. Well, yes, there might be the public defender's office might work on contract with local defense attorneys because there just isn't enough. Is a change of venue appropriate here? I think it's a bit too early because, well, here's the balance. The internet exists. So if they can just expand the jury pool and pull more jurors in, they have a better chance of finding people who haven't been exposed to this on the news, and aren't connected to the location. But is a change of venue appropriate? I don't know. This location has a very real interest. This community has a very real interest in prosecuting a crime that happened in their community. So finding a jury panel might need to expand the reach of where you're grabbing a jury panel from, but do you necessarily need to change the venue? I don't know. I haven't looked at the case law on the threshold for change of venue in quite a long time, but those are kind of my initial thoughts. So, question about the no contact order. What if one of the family members wants to contact him? Is he allowed to respond? No. No, he's not. I can't imagine that is the case. But no, he is not allowed to respond. So it doesn't matter if they want contact, he is not to contact them. Ignore me on the out-of-state registration. My ADT needs to keep reading. If you cross from Pullman to Moscow, is it not a federal crime? Not necessarily. Like, just crossing state lines doesn't necessarily, it makes it so that the feds could, but it doesn't necessarily pull it into federal court. So, this is a state crime. The feds determine what they take. Is the local area able to prosecute this just fine? Yes. Is this something that really involves multiple states in a way that this needs to be a federal crime, like a Jen Shaw 5-state telemarketing thing? Not really. This is a local homicide case. I don't think the feds, for prosecution purposes, need to be involved. EDB, please take care of you. This must bring up past cases. It does. It does. I'm getting better at processing vicarious trauma, but I also find that this community is so incredible that I want to make sure that we can answer questions and make sure that we process through the information in a way that still is not icky. I don't have better words for that. Amora said, do you think the male voice saying it's okay could have possibly been Ethan when he was still anything is possible? I mean, there were two males in that house, and we don't really have an order of timing, and I don't know if they ever will have an order of timing. It is possible. That is possible. And that might be information that's known or unknown, but that is possible. Do clients ever admit to their attorneys? Can their attorneys ask if they did the crime? I've never worked as a defense attorney. This is a great question for Natalie Lawyer Chick. She's probably discussed it. I don't know if a lot of defense attorneys ask their clients if they did it. Unless I imagine clients who are like, it's not me, voice that vehemently. But the conversations that defense attorneys have with their clients, I don't know. I think that probably would vary attorney by attorney, but I also think that that's probably better answered by Natalie Lawyer Chick. So I don't know if the defense attorneys I've worked with and been friends with have never said, this is the first thing I do is ask them, did you do it? I don't think that's a helpful way to start a relationship from, especially when I was doing high volume courts. Most of the defense attorneys would be like, hi, I am your public defender. It is my job to represent you. I'm here to represent you. I'm just getting this file. I'm going to review it. This is what we're going to do here in court today. This is open court so people can hear you talking. So what we're not going to do is have a chitty chat right now. I will come and talk to you in lockup, or I will call. They set the expectation for when they will communicate. They go through the file and do the arraignment and then go from there. Can law enforcement share more with the families now, or does the gag order prevent them? The gag order prevents public statements. So no, it doesn't prevent law enforcement from talking to the families unless, because this is making statements, extrajudicial statements. However, if it is seen that law enforcement is talking to the victims' families and then the victims' families are disseminating that information, it could be seen as trying to get around the gag order, and that could be hugely problematic as well. So keeping the victims' families in the loop and not trying to subvert this order is key. But this order specifically prohibits any statement which a reasonable person would expect to be disseminated by means of public communication that relates to the following: evidence regarding the occurrences or transactions, the character, credibility, or criminal record of a party, the performance or results of any examinations or tests, any opinion as to the merits of the case or claims or defense of a party, any other matter reasonably likely to interfere with a fair trial in this case. So, no. And, it's just, I think that they probably don't want a way around this. I think this probably limits them a little bit. So, Emily wanted to give a source of information is a guy named Andrew Teague about a car and a registration of the car. He actually named Bryan back in December. Okay. Um, the police had an eye on Bryan back in December as well. It's just that wasn't public let. Yeah, you mentioned that public defenders have no choice. They're assigned cases. Can they be punished if they're found to be not performing their best? I mean, most attorneys want to perform their best because they adhere to their own moral and ethical standards of wanting to do their best work. But the inner workings of a public defender's office is beyond my purview to comment on. Um, Skady, if the plates were expiring and they have footage of the PA plates and then the officer didn't find those cruising the lot, then I think they have an added point of planning that he did the crime, then changed the plates to avoid detection. I don't know. It looks like the plates were changed afterwards, but there's a reason why the plates were changed. I think there's a lot of strong evidence here. I don't know if the the date change or the change is going to be the biggest thing. So I don't think that's going to be the biggest thing. Is it possible this trial could happen this year? I mean, it is January. Anything's possible, but I think it's unlikely. But I don't know how busy this court is. The defendant could say, I am not waiving speedy trial. And if that happens, then yes, it is possible. So then yes, it is possible. Is it possible you will cover the documents from the arrest made in 2017 murders in the Delphi? I don't know if I will cover the Delphi case. I have not had time to jump into it, so I just don't know yet. Julia said, I was never bothered this much by details of a crime until I became a mom last month. Thinking about the mamas of these people having to say goodbye breaks my whole heart. Yep. Life events can definitely change our perspective, right? Salad bar, big hug. Thank you. Everybody needs it. Question: if he's a criminology PhD, doesn't it seem weird he would leave the knife sheath? No. I think this was there is not really a delicate way to answer this question. And I know that you didn't mean to ask a question that can't be answered delicately. This might have been well outside of his control. This could have been pulled off of him by a victim and he didn't notice. We know that some of these victims have defensive wounds. So it is my hope that these victims fought like hell and that's why this ended up there. Not that he callously dropped it, not that he was casual. It's that the victims were fighting and that's why this was left. But we don't know and we won't know. So it's it's possible that he didn't notice, especially because I imagine, I played water polo, so I've been in physical altercations. Um, there's a lot of adrenaline in physical altercations. I imagine that is similar, and that might zero down your attention to that type of detail to the thing at hand, which would be again taking the lives of 4 people in a way that they don't overpower you and call the police. So could it be that the victims pulled it and he didn't notice? Yes. Could it be that it fell in doing all of this? Yes. So we know that there are defensive wounds, and we'll see what comes out in the evidence on that down the road, possibly if we go to preliminary hearing and stuff. So yeah, I don't know if that was within his choice, but that's where the fight like hell comes in. Police involved in police PA, all involved have vicarious trauma, so please keep them in your thoughts and prayers. Yep. I mean, I feel for the officers here. I mean, as much as I feel for the victims' families, I feel for the officers. I feel for the officers who had to walk this crime scene and just be like, God damn. Like, we're in a college town. This stuff doesn't happen here. It's not, it's just all of this is awful. It's awful. It's hard work and it's awful. But you know what? They did their job and they really went through, okay, this is awful. Here's what we need, piece by piece by piece. Stephanie said DoorDash could have dropped off food and not physically handed it over to someone. Absolutely could have happened. Absolutely could have. As a prosecutor, what are the odds he'd get? We're way far ahead of that. First of all, the prosecutors haven't asked for that yet, so we don't know if that is a possibility. Second, we have not gotten to a conviction yet. And third, if they do, then that would go to a separate jury finding, and the jury would decide that. And we don't have a jury, so we're too far afield for that at this point, because that's way down the line. What I'd like to see is what happens at the preliminary hearing. That's what happens at the next hearings and how are we proceeding. That's kind of where my thoughts are. Anna P, thank you so much. Love your coverage. Thank you for taking the time to do this and help us understand the legal side. I read the affidavit and I'm very confused as to why the roommate didn't call the police after she locked herself in the room. If I was afraid to the point of freezing like that, I can't imagine not checking on my friends. I don't know. I just don't know. I don't know. And I imagine that if she testifies, the defense will absolutely ask these questions. But I also know we don't know all of this information. We just don't know. Do the cops have done amazing at getting him off the streets. They have definitely done everything they can to dot their I's and cross their T's from what we've seen. Do the families have to abide by the gag order? No. But the families should not disseminate information that's given to them by law enforcement. Coheed, hello. Sorry. Thank you for your coverage. Found you during Johnny Depp. Your knowledge and insight has been indispensable. Well, thank you. That's very kind. Happy New Year as well. This is a lot of evidence and has to be a lot of, yes, a lot of blood evidence. Do you personally think he will plead out to avoid the death penalty? I don't know if that'll be on the table for him. Is that possible? Yes, it can. Emily, didn't he cross state lines? He did. I think we've talked about that at length, but thank you for the super chat. I was going to send you a message to see if you were going to cover this case. I'm late. We'll be following it with you. I asked our members on Patreon and here if they wanted to cover it. So I asked the members, and the members were like, "Yes, we want to cover it." And yes, we want to know. So that's what I did. So, how long do we feel this will take to actually go to trial? It depends on if he waives his time or not. So we don't know yet. Let's get to the preliminary hearing first. There's a lot of information to process. It's a lot for the defense to process. So I'm sure they don't want it to take forever. And if it's not a super backed up court, could it go to trial in early 2024, mid 2024? Yes. If he doesn't waive time, it'll go faster than that. So I think Autumn, we talked about this. I don't think he'll choose to represent himself. I think that would be a mistake. Is there a difference with magistrate and judge? Well, there's a magistrate court, and it just depends on the designation. I haven't looked at how Idaho designates them. I know Andrea Burkhart did a breakdown of the courts a little bit in Idaho. Generally, the designation here, I think, of magistrate judge indicates the level of court, because this is in the magistrate court, which is going to be your like misdemeanor early court before it goes to felony court. So it's just indicating which court the judge is sitting in, and then this will go to it will go up to the district court after that. So I think it's just a designation of location and court level, not that they're like not a judge. Any idea whether roommate would not contact? No idea. So we're gonna and I really don't. I don't want to speculate, because that's got to be hard for it's got to be a hard thing to process too for the individuals that were there. So that I know it's not your typical trial, but are you consider covering this if it goes to trial? If it does, we will cover it, because criminal trials tend to be on, my brain has stopped. It's definitely time to stop streaming. But criminal trials tend to be televised more than non-criminal trials. And so I do very much enjoy and find helpful to go through criminal trials. We're going to be going through the Murdaugh trials, and the cases that everybody's talking about includes these. So I think we will. I think we will, but we'll see what happens. Violet, sorry if you don't need to apologize. But when is the Murdaugh trial starting? The Murdaugh trial is supposed to be starting January 23rd. Though yesterday I saw Mandy Matney share on Twitter that the judge that we all like so much, the judge's 40-year-old son passed away. I was just like, no, that's awful. Like my first thought was like this poor judge who was so lovely. Secondly, it seems like a big loss to their legal community. And third, I can't imagine what it would be like for a judge to try to preside over a trial where someone is accused of killing their own child on the literal heels um of losing your I just can't I was like, oh. So the Murdaugh trial should be starting at the end of January. Mileage may vary. Criminal trials get put over all the time, so we never ever know. So we never know, but it just broke my heart to see that for the judge. Patricia, will autopsy pictures be shown and where? Hopefully nowhere public ever. Those should always be private, but if they need to be in court, they will be limited and they will be in court and they will not be public information, nor should they be. Question, do they need his exact DNA or is the dad DNA enough? For these purposes, the dad DNA is enough, but now that they have him arrested, they will also do his. So they will have more. But for the probable cause, the familial DNA is probably more than they needed with all of this. They added it in, but it's more than they needed. How did the feds know to go to Pennsylvania? I'm so curious about what tagged them to his parents' house. The phone was registered to the parents' house, and the car was registered to the parents' house. And then they knew he was on the way to the parents' house because there were those two traffic stops, and the dad, not the defendant. The dad was like, "Oh yeah, well we're driving to Pennsylvania." The dad was very chatty. The defendant was like, "We're going to get Thai food," and the officer's like, "You're not in your state." And so the dad was like, "No, well, we're driving from Washington to Pennsylvania." The dad was the one who was chatty in those traffic stops, not the defendant. I imagine the defendant was sitting there being like, "Shut the fuck up. Shut the fuck up. Oh my God, shut the fuck up. I just said we're going to get Thai food." No, you're not just going out to lunch, my guy. You're driving cross country. But again, leading me to believe that the dad was like, "I went and got my son at school and we're going back to Pennsylvania on a wee little road trip. See the country. It's going to be great. We're going to stop at Texas Roadhouse. It's the cinnamon butter is delicious. It's going to be fantastic. We're going to be out of range of an In-N-Out, like the road trip things that you would think of. What are the best places to stop? Are there any Buc-ee's between Washington State and Pennsylvania? I don't know. Do you have to dip further south for that? I think you do, which is disappointing. You don't even get a racetrack until you're like well through the middle of the country. Anyway, that's a whole tangent on my love for gas stations. But the dad is very chatty, which again, I think that the dad probably didn't know. So how did they know Pennsylvania? The cell phone was registered to Pennsylvania and the car plates were registered to Pennsylvania. And we learned that in that probable cause affidavit. They are adding Buc-ee's here in Middle Tennessee. We heard that Thai food was great in Indiana. Indiana. Yes, they drove it. Now I want cinnamon rolls and better. Right. Sorry, y'all. I'm hungry. PCA state suspect number 1. Does that include more suspects? I didn't see it state suspect number 1. I saw it say suspect vehicle. Let me look. No, it doesn't. It necessarily. It indicates that that's how they were designating him before they knew it was him. So let me just take a look. Because I remember them saying suspect vehicle. I just don't remember it. And again, I will read this more before we cover this case more. But this case is, other than court hearings, will probably be pretty quiet in between. I remember suspect vehicle 1, and that designation is fair because there can be more than one vehicle, but I think they've always named him by name every time they referred to him. So I could just control F myself and see. Let's see every time it says suspect. Will it search this PDF? No, not searchable. That's not helpful. All right. I'll take a look at another time, but I think it was just suspect vehicle number 1. So likelihood he pleads out. I don't like putting likelihoods on things. I don't know this defendant. I don't know what these DAs will offer. I don't know if he'll be offered anything, so I don't know. So he mentions the murders in one of the traffic stops. I did not see that. I saw him talking about a shooting at Washington State. So I will go back and look at those again. You guys are asking, what's a Buc-ee's? How do you describe a Buc-ee's? I will let the chat describe a Buc-ee's, but how would I describe a Buc-ee's? It's like, I don't know. It's like a rest stop. It's a gas station, but like a Costco. Like if Costco was gonna do a gas station, that's a Buc-ee's. Buc-ee's has food. Buc-ee's has merch. Buc-ee's has the cleanest bathrooms you will ever seen, and tons of them. Disney World of gas stations. All of the merch. My kid now has Buc-ee merch. All kinds of snacks. A wall of beef jerky. They make fresh food. They make everything. It's huge. So it's big. It is all the things. They have all of their own types of food. I have Buc-ee's. I was gonna show it on stream. I will find it. I got it for the members only stream, but they have like overbite chocolate that has like the Buc-ee's beaver on it. I thought it was the funniest thing ever. They have branded candy and chips and food and snacks and everything. It is a mega station and it is a destination. So like the Loves, no. Buc-ee's is a thing. It is a thing. It is a hyped thing. They have no, I have not gotten my all dressed chips yet. And Buc-ee's doesn't have them. Damn it, Buc-ee's. Is it Wawa of the West? Not really. Buc-ee's is bigger than the Wawa's. Wawa's is great. Wawa's more like a racetrack. Buc-ee's is bigger in the Costco sense of big. And like Costco has their Kirkland brand, Buc-ee's has Buc-ee's brand, literally fucking everything. And more places to get gas and more bathrooms. So it is a whole thing. Question: what does waiving time for speedy trial mean? That is a great question, bringing us back from Buc-ee's to we were lining it up. Oh, I know Costco has gas, but Costco's like a Costco and you can get gas if you remember. Buc-ee's is like a Costco gas station. It is like versus like a travel destination on a road trip. You want to stop at a Buc-ee's if a Buc-ee's is an option, because it's its own thing. I think they started, I'm pretty sure Buc-ee's started in Texas. So but it's like the destination. Costco, here's the thing about Costco gas, or at least where I lived in Southern California. Costco gas, you are waiting for fuck ever to get into Costco gas because they have like 12 pumps. Buc-ee's has so many gas pumps. It is a field of gas pumps before Buc-ee's. It is a convenience store Costco thing. I was going to answer a question, damn it, and then I clicked off of it, and I am sorry. I forgot what I was going to answer. I was going to waiving time. So there are statutory times to go to trial. And if you don't waive time, you go to trial within the statutory time. And so the judge said that the preliminary hearing, I don't remember the amount of days. I think the judge said 15 days. I could be wrong on that. But the judge gave the certain amount of days. You'll go to preliminary hearing in X number of days. That is the statutory period that you need to go to preliminary hearing within that period of time. And for trial, there is you need to go to trial within this many days. The defendant can waive time and say, no, we're not ready to go to trial. And especially in a quadruple homicide where evidence is still being processed, their defense attorney might just not be ready within the time period. And you can waive time and say, okay, we're waiving the right to a speedy trial. I have the right as a defendant. I have the right to a speedy trial, but I need more time. And the defendant has the right to say, but I need more time. We're not going to trial in the period. Or the defendant can say, fuck you, go to trial. So Aaron said speedy trial limit in Indiana, my brain ID. Idaho is 6 months. So the defendant can say, no, go to trial. Go to trial. Go to trial. And that's what Murdaugh did. Murdaugh was like, good luck. I hope you have your evidence together because I am not waiving time and we are going to trial. Sometimes that works well for a defendant. Sometimes it doesn't. In the Murdaugh case, when they've waited a year to arrest someone, one would hope that the prosecution and police are ready to go to trial. The feds are generally ready to go to the trial. By the time they indict somebody and do a grand jury, they're like, it's done now. Let's go. Their case is ready to try generally by the time they arrest somebody. That's different in state level cases. In state level cases, I'm sure these officers wish they had 6 months before they had to arrest somebody to work up this case and be ready to go. They don't. They are still working this case day in and day out to get it ready for trial. There are more search warrants I'm sure they want to do. There are more things that they want to do in this case to get it ready for trial. So they are not done. This is still an ongoing investigation, even though they've arrested someone. They can't just let it go. The public was like, is there going to be an arrest? And they knew who this was. They had connected him to the vehicle and they were waiting till they had enough to grab him. So I think they arrested him in pretty quick time. So, Emily D. Baker, hi, Elliot. If law enforcement officers determine the defendant is a suspect in additional crimes committed out of state, how will those charges trial be handled one after another? Generally, it will not be added to the same case. They will just do this case, and then he will be extradited to whatever state to stand trial in whatever state if that happens, and that can happen. So. Just home from work, rough day. Seeing you live has put a smile on my face. Thanks. It's a rough topic, but thanks. Why is the judge saying kill and murder? Aren't they the same thing? The judge is reading the statutory language, so that is the statutory language in the sentencing document. Thank you for covering. Please remember to take care of yourself. I will. I'm going to actually wrap up pretty soon. The PCA seems at this point to give a strong enough case to the prosecution. Defense looks to have an uphill battle. The defense always kind of has an uphill battle because they are always given. There's always a lot of work that's happened before the defense is brought into it. But yes, this is a lot. Will there be one trial or four? One. There is one defendant, and though there are multiple victims, there is one defendant. So there is no reason to parse these out victim by victim, and they are all charged in one charging document. Making sure chat sends love to Hogue as he recovers. We talked about Hogue a bit yesterday, and my desire and hope was that everyone would go and watch the videos they hadn't watched, watch the playlist they hadn't watched, catch up on the hangouts and headlines, and continue to support his channel while he is recovering. What is the difference between found guilty and pleaded guilty? Pleaded guilty means the defendant said, yo, I am pleading guilty. Found guilty means a jury has found them to be guilty, though the media sometimes doesn't differentiate well. That's what I mean. So Christy said she froze. Similar happened to me when I was 12 and my mom's boyfriend broke in. I pretended to be asleep. I didn't move for hours till my mom came home, was afraid, and just froze. And that's fair. I'm not going to judge truly people's reactions, and I'm sorry that happened. It must have been terrifying. Because you never know how people will react. And it's so easy to be like, well, I would have done this. You don't know. We don't know. We hope we would do something, but we don't know. And I'm sure that the surviving roommates are going through it. So I'm not gonna add to that speculation. Are those questions that will need to be answered in trial if this goes to trial? Yes, it will need to be discussed if this goes to trial. Is this something that needs to be discussed today? No. 2 questions. Doesn't the no contact rule restrict the defense attorney's ability to subpoena? No. This is the defendant not having contact with them, and the defense attorney probably doesn't need to subpoena. I'll get to that. Second, the way she said no threats or harassment, shouldn't that apply to everyone? Orders have to be specific, and you have to say what people aren't allowed to do. So that's why that's there. But does this restrict the defense's ability? No. And in a case like this, you would generally, if it gets to the place where you are going to have live witnesses and the defense needs to interview them, they will coordinate with that with the district attorneys. The district attorneys have to make those witnesses available, so it's not a problem. That discovery stuff will get taken care of pretty easily. Thank you for all you do. You're welcome. This document is rough. It is. It's heartbreaking, and it's just heartbreaking. But it's some answers, and hopefully that helps people be at ease. Jen, thank you for the catnip tip. I'm sorry to your law nerd loss. It is or your paw nerd loss. It is very hard to lose a paw nerd. It is indeed. Oh, Heart Warrior Mama, do you think he planned to do this around his birthday to give him a reason to change his tags? I didn't notice the date of birth. Do I think that the change of tags could have been a circumstance that he exploited to his advantage? Possibly. I don't know how long of a case or how long of a period of time that 12 visits were. But if this is something that had been planned for months and months, yes, it is. it is fair to think that he looked at circumstances and looked at circumstances that he could exploit. Hey, I've already got a trip planned home for the holidays. Hey, I'm going to be changing my license plates. It's possible that he used those circumstances that had an explanation to his advantage, depending on how long he had been planning this. So yes, that is possible. It is also possible that that he planned for this to be at night, knowing that people would be out and could be drinking and might not be as aware or capable due to said drinking. Okay, I'm going to answer just a few more questions. I know we have questions for days, and then I've got to wrap up because I have to wrap up. Was it something specific to that day? What is something specific to the day that you are grateful for? Shelly, is this a question for me or a question for the chat? I'm constantly grateful for y'all. I'm grateful to be able to do this. I'm grateful that this is what I get to do. And we get to, even though it's hard things, that we get to parse through them with all of y'all. So I am grateful for the law nerds. Wait, no. He did not plead guilty. We were just talking about the difference between plead guilty and found guilty in a general sense, not in this case. No. That would be a headline. Question, does suspect vehicle 1, does that indicate more than one? No, it's how they designated it because there can be more vehicles. So that's just a designation. That's not, I don't read more into it than that. So that answered Heart Warrior Mama. I want to know what happened, but it's giving me such anxiety. I get it. We know what we're going to know, and this is all we're going to know for now. There are going to be things that we are not going to know. Could this case be reassigned to the federal? No. They would have made that decision earlier, and no, this is a state prosecution. They have jurisdiction here. Are you surprised they released the affidavit since they placed a gag order on the case? No. I think the gag order and the affidavit makes sense because it's like, here's the information that you're getting. That is all. You are getting court records. That is it. Everyone's on the same page. Happy idea. Have you looked into adding ponytail hats as an option for the shop? No, though my friend my friend Ari has split her fax hat so she can't put a ponytail. I have not found a supplier for ponytail hats yet that I like. How do police handle this? It's heartbreaking. Police have a very difficult job. First responders have a very difficult job. Criminal lawyers have a very difficult job. There are a lot of people that ER nurses have a difficult job. Lots of us have difficult jobs. I think the thing is that police choose to do this and hopefully take good care of themselves. Not all of them do. It takes quite a toll. Our first responders bear quite a toll of the job that they do, but we would not function without them. So anyway, yep. So Aaron said he just got his charges today. He will plead in 14 days. I need to take a look at Idaho. In California, you generally plead arraignment, but that's not the same, which is why I didn't really talk much about it. It's not the same in every jurisdiction. Did I look before we streamed? No. I will always tell you when I do and when I don't. So, question, do you think that they have other sources of DNA at the scene in addition? It's possible. It's possible. Question, have you seen the look of fear in his face when he gets pulled over? No, I didn't. I read Curiosity, but I'll go back and look at it again. Can he sue the state if he's found not guilty? No. Or if investigators find a different suspect? No. They're doing their job and they haven't done their job outside of, from what we've seen, they haven't done their job outside of their ethical duty. So we've not seen anything where he could sue. I mean, being wrongly accused or wrongly arrested or police making a wrong conclusion, if you are not lying about evidence or making things up, is generally not a crime. It can happen. All right. With that, y'all, thank you for being here. Thank you for being law nerds. Thank you for riding with me today. This has been an almost 4-hour stream. Emily, can we ever keep it short? No, we can't. No, we can't. We are a long form streamer. Tomorrow is the Jen Shaw sentencing hearing. I will probably update you on that in quick bits unless there is something wild. More fulsomely maybe in our member spaces and then back on Tuesday. So keep an eye on the quick bits channel and on social. If I do some reels or something, I will post those. That is my intention. I don't think we need to do much more than that for Jen Shaw sentencing. She's going to get some number of years and we'll know what they are tomorrow. And she's not going to go into custody tomorrow. So we'll do that. Natalie Lawyer Chick is covering this at 5:30. Fantastic. I will be checking in And I always recommend Natalie Lawyerchick. I love hearing her perspective. I'll be interested to hear what she has to say. And then maybe, down the road, we'll do a lawyer panel and talk all about this at some point. But for now, it is time to go. I will update you in all the spaces. So Quick Bits is my shorter videos and shorts channel. The podcast video will be out. Oh, it's 4:00 tomorrow. It's just gonna be till tomorrow. We'll be out tomorrow. So I will have a new video and a premiere for you tomorrow, and then we will go from there. So if you want to hear the podcast early, it's on all the audio apps, and that's out today. Yes, today, and it will be on video tomorrow. So I will talk to you soon. Thank you for being here. Thank you for being a law nerd. Thank you for doing the YouTube-y, likey, subscribey things, and I will talk to you guys soon. Probably on Tuesday at 11, like always. Unless you're watching this after Tuesday, and then maybe you'll see me on a Thursday at 11. Podcast every Wednesday. Okay, bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.